Okay, members, thank you for joining us today for the Justice Committee. Just to give a brief overview of our business, the oral evidence sessions on the Justice Sexual Offences and Trafficking Bill with CARE NI, Migration Justice Project, Bernardo's SPCC and the NI Commissioner for Children and Young People. So we have a considerable number of briefings from the oral session. Further informal deliberations on the Protection from Stalking Bill and consideration of the possible amendments to the bill, consideration of further information in relation to the October monitoring round, and also consideration of the forward programme. Just to advise members that they are welcome to use the mobile devices as long as they're in the airplane mode, and all devices are muted. This includes members' tablet devices. They can connect to the Assembly Wi-Fi. Also to remind members that we are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to a matter under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Can I get the agreement of members for the oral evidence sessions on the Justice Sexual Offences and Trafficking Bill and the Committee's informal deliberations on the Protection from Stalking Bill to be reported by Hansard?
Agreed.
Apologies. We have an apology from Emma Rogan, and just to advise that Doug, Gemma and Peter are joining by, and Sinead are joining us by Starleaf. So you're very welcome. Rachel is here in person, and Robin Newton has sent a note to say that he'll be late at the meeting. Just to advise members, those that have indicated they have delegated authority to vote on their behalf is provided by the Standing Order 115, and Emma has delegated her vote to the Deputy Chairperson, Sinead. Item 2 is the agenda, the draft minutes of the meeting held on the 4th of November, pages 5 to 13 of the meeting pack. Are you content that the minutes are a true reflection of the proceedings of the meeting held on the 4th of November? Agreed?
Agreed.
Thank you. Agenda item 3, matters arising, and there are currently no matters arising to cover the minutes. That brings us then to agenda item 4, which is the Justice Sexual Offences and Trafficking Victims Bill oral evidence session for CARE NI. Representatives from CARE NI are attending the meeting in person to provide the oral evidence to the bill, and a copy of the CARE NI's written submission is at pages 16 to 39 of the meeting pack, and a copy of the bill and the explanatory and financial memorandum is at pages 40 to 91 of today's pack. Can I welcome to the committee this afternoon Lauren Agnew, the Human Trafficking and Sexual Exploitation Policy Officer and at CARE, and also Rebecca Stevenson, the NI Policy Officer. And just to advise you both that the session will be reported by Hansard and a transcript will be published on the committee's website, so you're both very welcome. Just also, I'll invite Lauren to briefly outline the key issues in relation to the provisions of the bill and to grasp to outline for us the issues that CARE wish to draw to our attention. And as I said again, you're very welcome to the committee. Thank you.
I'd like to thank the Justice Committee for the invitation for CARE NI to give evidence today. I'm Lauren Agnew, Human Trafficking and Sexual Exploitation Policy Officer for CARE, and this is my colleague Rebecca Stevenson, Northern Ireland Policy Officer. I want to start by thanking the Assembly for all of its support for victims of human trafficking and for pioneering legislation solely on human trafficking in 2015. Regrettably, despite that legislation, human trafficking and modern slavery is still happening here in Northern Ireland. Last year, there were 128 potential victims of human trafficking. 20 of those were children. These are not just statistics. These are individuals whose lives will be impacted by changes which the Northern Ireland Assembly can make through the Justice, Sexual Offences and Trafficking Victims Bill. CARE supports the changes that will be introduced by the Justice Bill on human trafficking and exploitation. In particular, we welcome the change introduced by Clause 16, which will extend the statutory assistance and support provided under Section 18 of the 2015 Act to adult potential victims of slavery, servitude, or forced labour, where there is no element of trafficking. This support is provided only while the Home Office determines if someone is or is not a victim through a process known as the National Referral Mechanism, or the NRM. However, since 2015, evidence has shown that those who are confirmed as victims of modern slavery need long-term support to recover, avoid re-trafficking, and assist the police with their investigations of the perpetrators of these horrific crimes. In Northern Ireland, Section 18(9) of the Human Trafficking Act provides for support to be continued only on a discretionary basis following a positive, conclusive grounds decision. As it stands, Northern Ireland is currently providing statutory support for potential victims of human trafficking, but not confirmed victims. The current channels for supporting victims of modern slavery after the NRM, however, are inadequate, leaving many victims homeless, destitute, and vulnerable to re-trafficking. NGOs working with victims recommend they need at least 12 months support. In Northern Ireland, Flourish, who work with trafficking victims once they have exited the NRM, have said that without support, clients face significant barriers to moving on. This could include social isolation, re-exploitation, homelessness, poverty, mental health issues, alcohol or substance misuse, and a general lack of capacity to thrive. Last week, at the event hosted by the APG on modern slavery, the UK Independent Anti-Slavery Commissioner, Dame Sarah Thornton, also highlighted the importance of prioritising victim support to enable victims to become survivors. Comprehensive victim support is not an optional extra. It is also essential to tackling the criminals behind modern slavery by enabling victims to provide their vital intelligence to criminal justice proceedings. Longer-term support would help victims feel safe and secure enough to engage with police, assist with investigations, and even give evidence in court. This level of intelligence would increase the number of human trafficking-related prosecutions and convictions, something desperately needed, which in turn would send out the message to human traffickers that Northern Ireland is not open for business. A victim's stability is a central pillar of both recovery and engagement with prosecutions. CARE recommends an amendment to Clause 16, which would provide 12 months statutory support for confirmed victims of trafficking. This would include safe accommodation, access to benefits, counselling, medical care and education. If the Assembly were to vote in favour of longer-term support for victims who have received a positive, conclusive grounds decision, Northern Ireland would once again be leading the way across the UK on support for victims, as it did through the passage of the groundbreaking Human Trafficking and Exploitation, Criminal Justice and Support for Victims Act 2015. Finally, I'd like to discuss the reform of the Criminal Injuries Compensation Scheme, or the CICS. In Northern Ireland, there have been a total of 10 applications in the last 5 years, 8 of which have been denied, and 2 are currently being processed by compensation services. A number of significant legal barriers have been identified that mean that many trafficking victims are not eligible for compensation under the scheme. We suggest a reform of the current system to ensure that victims receive the compensation that they are entitled to. This bill is aptly called the Justice Bill. By providing long-term support to confirmed victims of human trafficking and modern slavery and improved access to compensation, that is exactly what it would be achieving: justice. Human trafficking remains a high-profit, low-risk crime, but the provision of 12 months statutory support post-NRM would enable and empower victims to help bring justice to those who have exploited them.
Mr Chair, I would like to extend my thanks to that of my colleague Lauren for inviting us to speak to the committee today and reiterate her thanks for the work being done in Northern Ireland to enhance protection for the victims of human trafficking. At CARE, we welcome this Justice Bill and the changes that it will introduce. That said, we believe that this bill could go even further to protect victims from crimes being committed and increase prosecution if the committee were to adopt some changes, and I would like to briefly discuss these now. As has been published widely in media in recent months, the number of potential victims of modern slavery is increasing. Despite this, the number of prosecutions for modern slavery and human trafficking offences remains low. While the Human Trafficking and Exploitation Criminal Justice and Support for Victims Bill provided an excellent foundation for protecting victims from individuals who may commit a trafficking offence, it does not contain risk orders. Only Slavery and Trafficking Prevention Orders, or STPOs. These STPOs can only be made when a person has been convicted of a modern slavery offence. On the other hand, a Slavery and Trafficking Risk Order, or an STRO, which are found in the Modern Slavery Act 2015 and are currently applicable in England and Wales, can be made on application to the court where a person's behaviour indicates that there is a risk that they may commit a human trafficking or modern slavery offence, and that this is an order that is necessary to protect the public. In Northern Ireland, the introduction of risk orders would prove helpful in two specific circumstances. Firstly, where a defendant is convicted of a crime other than human trafficking, but where there is suspicion that trafficking may have been involved, or there is a connection between the human trafficking and that offending behaviour. Or secondly, in situations where people have not or not yet been convicted. This includes situations where there is a need to protect future victims while modern slavery or human trafficking crimes are being investigated. It is also worth noting that in her recent visit to Stormont, the Independent Anti-Slavery Commissioner discussed STROs, and in her 2019-2020 annual report she stated that the risk orders can be particularly helpful when investigations are lengthy and make it possible to protect victims prior to prosecution. In Northern Ireland, the legislation did not include risk orders, but I urge the Justice Minister to reconsider their value as evidence of effective use in England and Wales and Scotland. The Criminal Justice Inspection Northern Ireland report on modern slavery and human trafficking, published in October 2020, also highlighted that these orders could not be used against people who had not been convicted but posed a continuing risk of committing trafficking crimes in Northern Ireland. A report commented on the experiences of England and Wales, saying these civil orders were seen as an important tool in preventing slavery-related harm before it could occur and preventing reoffending. The report recommended that the Department of Justice consider introducing STROs. This bill would be an opportunity to prevent trafficking offences, which we urge the committee to consider, including risk orders in the Justice Bill. Given the complex nature of modern slavery cases, at CARE we believe that there is a need for juries to be given direction in such cases, which will enable them to approach court evidence in an informed manner and provide the greatest opportunities for victims to receive the justice they deserve. This echoes recommendations that were made on 2 occasions by the Criminal Justice Inspection Northern Ireland. If this recommendation were accepted, then Northern Ireland would once again be a UK leader. Thank you for this opportunity to speak, and Lauren and I would be happy to answer any questions you have.
Thank you, Lauren. Thank you, Rebecca, for your presentations and also for your very comprehensive and persuasive case that you made in your submission to the committee, and it is very much appreciated. Just can I pick up on a couple of things. One, are you content that the commitment by the Minister to publish the annual progress report on the human trafficking strategy, or is there a need for the legislative provision to be in this particular area?
We welcome the commitment by the Justice Minister during second stage reading of the Justice Bill to commit to annual updates, and we think that would be sufficient.
And obviously in your submission you make the case to extend the statutory support to victims who have a positive conclusive decision for a period of 12 months. Have you any idea or as to why it seems as though the department has not taken the opportunity to include this in the bill?
I think whenever it comes to the crime of human trafficking, we are continually learning more about victims' needs, and I think there is a unique opportunity in this Justice Bill to go further than Clause 16 and to actually extend long-term support on a statutory basis post-NRM for a period of 12 months. And at a basic level, in Northern Ireland, we are currently supporting victims when there is a question mark over whether or not they are a victim, but we're only providing support on a discretionary basis to confirm victims. And as I was saying, lack of support leaves victims at risk of homelessness, destitution and re-trafficking. Victims of human trafficking experience extreme trauma at the hands of their abusers, which they can't articulate in the immediate aftermath, and they may also be fearful of the police. So they need time and stability to enable them to begin to assist police in investigations. And the police and the PPS would also know their whereabouts and be able to approach them to act as witnesses in criminal cases against traffickers. And increased engagement with police would lead to more prosecutions, which would lead to more convictions. And human trafficking remains a high profit, low risk crime, and we need to change that in order for the legislation to act as a proper deterrent. In 2020, there were 36 recorded cases of human trafficking, crimes and exploitation. There were 3 prosecutions and there were 0 convictions. And since 2017, there have only been 4 convictions.
Okay, we're going to go to members for questions if they could indicate who I will endeavour. I think Peter Weir has his hand up, so we'll go to Peter first, and then I don't have, just so members are aware, I don't have on my screen at the minute you having your hands up, so if you wave or do something, I'll try and make sure that we get to you. Okay, well, Peter first, thank you. I don't forget about your date, so you know that.
Maybe my lack of knowledge of technology, whether it's actually the device I'm using, it doesn't appear to have anything other than me sort of giving a physical sort of hand wave to indicate. So thank you. I thank the representatives from CARE for their evidence. I suppose just want to tease out just a couple of questions. I think you've made very good arguments. In relation to the extension of provision for the 12 months, obviously there's a very strong case that you've made in terms of both protecting those very vulnerable people, and I think the moral duty that we have towards them, but also that it would play into both preventing further trafficking and also helping the prosecution of trafficking. But I suppose in terms of the inclusion, obviously just by way of have CARE done any scoping of what they believe the resource commitment that would be needed then from the department then to be able to meet those needs? Because I'm conscious sometimes we'll ask the department, or indeed any department, sometimes they'll be slightly vague in terms of the level of resource commitment that would be. And I'm just wondering if maybe there'd been any scoping out exercise by CARE in relation to that potential provision.
Thank you, Peter.
Thank you for that great question. I think as a basis for my answer, I'd like to stress that these are individuals that we're talking about, and yes, there are financial costs to incur, but ultimately we are looking at changes that would make a real impact in the lives of vulnerable individuals. And it's important to remember that the Assembly in October 2020 unanimously supported the motion tabled by the chair of the APG on modern slavery, Joanne Bunting, MLA, which called for consideration of further support for victims of trafficking beyond the end of the support provided under the National Referral Mechanism. And providing 12 months of statutory support post-NRM would help the limited number of confirmed victims in Northern Ireland who have leave to remain access the kind of sustained support needed to help them begin to rebuild their lives. And a change from discretionary support to 12 months post-NRM support would make a significant impact in the lives of these specific individuals. And according to an Assembly question, 34 adults received post-conclusive ground support between 2015 and February 2020. So that works out at around 7 a year. And it's estimated that between 35.5% and 47.8% of people who have a positive reasonable grounds decision subsequently receive a conclusive grounds decision. So based on the 2020 NRM statistics, this would result in approximately 45 adults potentially being entitled to government support. So that means that looking at last year, around 38 people a year were not getting the additional support that they could have been entitled to. And to answer your question, these are small numbers, but we do need to think beyond the statistics, because this change would make a significant impact in the lives of these individuals. But we do recognise that currently only those individuals who you're British citizens or have leave to remain, either as an asylum seeker based on humanitarian protection or the current discretionary leave to remain for victims of trafficking, would be able to access this support, and the immigration status is a matter determined by the Home Office. But that brings me to my next point that I would like to flag to the committee. This Justice Bill is being considered at exactly the same time as the Nationality and Borders Bill is being considered in Westminster. At CARE, we would like to see all victims across the UK receive at least 12 months post-NRM support and leave to remain. And it's disappointing that the Nationality and Borders Bill, currently being debated at Westminster, with a whole part of the bill and 12 clauses covering modern slavery, does not include provisions for long-term statutory support for victims of modern slavery in England and Wales, nor long-term leave to remain for all victims. And we are campaigning on these issues during the passage of the bill. And in 2019, Nottingham University did a cost-benefit analysis of providing support and leave to remain for 12 months to victims in England and Wales, and they found that there would be a direct and indirect financial benefit to the government of providing victims with this support. And just to elaborate on that, Northern Ireland is in a position once again to lead the way by voting in favour of long-term statutory support, because this would also put pressure on the UK government to change their policy on immigration leave. So Northern Ireland have a strategic opportunity to highlight the failure of leadership at the UK level on immigration leave for confirmed victims of trafficking by drawing attention to the fact that the only reason why all confirmed victims of trafficking in Northern Ireland couldn't access long-term support would be because the government refuses to grant the requisite 12 months leave to remain in order to receive 12 months support. So voting in favour of 12 months support would make a real difference in the lives of the individuals in Northern Ireland who have leave to remain to access this support. But more so, I would urge the Assembly to take this strategic opportunity to apply pressure to Westminster and to act as a catalyst for change for victims of modern slavery across the UK.
Okay, thank you. The other point just I wanted to ask, in terms of the STROs, obviously the more that we can act to prevent crime happening in the first place, particularly as regards the horrors of human trafficking, the more that it can help protect vulnerable witnesses, vulnerable people who may then be subject to potentially re-trafficking. And indeed, the more that this will also help with levels of prosecution as well. I suppose, if you like, we potentially, you mentioned in previously in terms of the 12-month period, that it's a question of, Northern Ireland having the opportunity to show leadership and be ahead of the pack. I mean, with the STROs, as you've indicated, that would apply in other jurisdictions, in many ways we're actually trying to do a level of catch-up. I just wonder, in terms of any discussions you've had with the department in relation to the potential for STROs, that on that basis, has there been a question of simply this has been something which you feel the department hasn't really just got around to, or are you detecting any level of fundamental opposition from the department to widening the scope to introduce STROs?
Thank you so much for that question. I think at CARE, the first thing I'd like to outline is we want to make sure that Northern Ireland has every tool to prevent trafficking from happening. And as you have correctly pointed out, STROs, or slavery and trafficking risk orders, are one of the tools that are available to prevent that from happening. I am not aware if we at CARE have had any discussions with the department, but I think that is a really excellent opportunity, and with the Chair's permission, that's something that we will look into, and I will write to the committee and let them know how we've gotten on.
Thank you.
Okay, I think that would be very useful. Thank you, Chair.
Thank you.
I'd like to just add
yes.
That in the DOJ's modern slavery strategy, they have 3 strands: to protect, pursue and prevent. So I would imagine that the STROs would fall safely within the prevent strategy, and that they should be amicable to introducing them.
Okay.
I mean, I think the point I think you make very validly as well is that ultimately, if we're obviously putting through the legislation at present, there is a golden opportunity to do that, as opposed to, for example, being in a situation that, in terms of an annual report, say in a year's time, it is something that is recommended and then legislation has to be brought in. I mean, I think maybe we should try as much as possible to be at least ahead of the game, or at least not fall any further behind in relation to the issue.
It's definitely something that I think the committee should consider, especially given the recommendation from the Independent Anti-Slavery Commissioner as well.
Thank you. Sinead Bradley.
Thank you, Chair, and thank you for the presentation. It was similar. I was eager just to try and understand if there was any resistance from the department, and maybe to understand if there was, why. But also on a technical front, I suppose the wording in the proposed amendment is quite detailed. And I wondered, is that a lift from other legislators, although it's been tailored, I understand. I'd just like to understand the wording of the proposal a little bit better, or the source of it. Thank you.
Yeah, that would have been taken from existing legislation, so it would very much be a case of mirroring that. And as the member previously mentioned, it would be a case of Northern Ireland playing catch up in this area, whilst in other areas of this bill there's the opportunity to lead the way. So it's very much a mixed bag.
Thank you. I do appreciate that clarity, because it is quite well presented, and it does work in, reference to Chief Constable, etc., just to lay, not just a proposal of a notion or an idea, but it actually lays out a map of who plays what role. So I'm very thankful for that. Thank you, Chair.
Thank you, Sinead. Rachel.
Thank you, Chair, and thank you for your presentation, your very detailed submission. I have just on the two issues that you've highlighted, I'll take the STPOs and STROs, and just want to tease out about that. That is already in existence in England and Wales.
So STROs are currently in the Modern Slavery Act 2015 and are currently applicable in England and Wales.
And could you give us some information on the effectiveness and on their use, if possible? If not, completely understand. But just if they, are they being used, or is this something that obviously authorities have, but are maybe not utilising as much, or maybe it's a bit too early if they hadn't been maybe commenced or not?
So thank you for your question, and to get the detail on that, I'm going to need to come back to the committee, and I will write to the chair. But just as I previously outlined, there are particular circumstances when they can be particularly useful, and that is when a defendant has been committed of a crime other than a human trafficking offence, but there is suspicions that there's human trafficking crime going on. Beyond that, so for example, where people are convicted of controlling prostitution for gain or brothel keeping, as human trafficking and modern slavery crimes are very complex and difficult to investigate, it can be difficult to gather all the necessary evidence in relation to such cases. And, we know from England and Wales that there are crimes are flagged by the CPS as having indicators of trafficking, but are ultimately prosecuted for other crimes. So there are indicators that they have been used in situations. And the second situation is where people have not yet been convicted of a crime. This includes situations where there is a need to protect future victims while modern slavery and human trafficking crimes are being investigated, especially where such investigations are very long and drawn out. And as I previously stated, the Independent Anti-Slavery Commissioner last week in her visit to the Assembly and in her 2019 and 2020 annual report made reference to risk orders, namely that they can be particularly helpful when investigations are lengthy and to make it possible to protect victims prior to prosecution. And again, in her report, she flagged that in Northern Ireland, the legislation does not include risk orders, but she urged the Minister for Justice to reconsider their value as the evidence of their effective use in England, Wales and Scotland emerges. So I will write to the committee with that specific detail.
Thank you very much. I appreciate that. I just on the amendment that you've included in the pack, I know it says reference about not leaving the UK and then about foreign travel being curtailed, but I'm wondering if there's been any discussions with the government in the Republic of Ireland about, obviously with specific issues here about cross-border travel between the Republic of Ireland and Northern Ireland and then onwards into the UK. So I whilst appreciate in terms of the foreign travel in the UK, there may be some issues arising, especially if traffickers are maybe living on border areas and using the border in that kind of way. So just wondering if there's been any discussions with them.
There's been no discussions that I'm aware of, but I think that's a great point that you've flagged and definitely something that we should look into going forward.
Thank you. Finally, just on the long-term support, and I completely support what you're saying in terms of the 12 months, but I suppose maybe taking it further, if someone has got a negative conclusive grounds decision and then we're appealing it, would you support continuing on if there was an appeal?
I think that's a great question, and that's not something that I have considered in depth, but I think ultimately, as we are currently providing support, when there's a question mark over whether or not somebody is or is not a victim, that would essentially be an extension of that period of time when there is a question mark. And if we cannot say that they're not a victim, I think, yes, we should be providing support.
Just on that issue of support, just to clarify, for me, does the financial resource in relation to all of that currently still come from the department? Or is it some of it Home Office? And the reason why I ask, because this week, or last week, I had discussions with the company that has the contract to deal with asylum seekers. That's purely a Home Office funded process, which is in dire straits. If you think of the number, like it really is appalling, the number of asylum seekers that we now have in Northern Ireland, the way they've been treated, and it has doubled almost. But is it the Department of Justice that fits the bill in terms of the human trafficking element of this?
I think they do, yes,
Yeah.
I think they do. And as it stands, Flourish are an excellent charity who work with victims of trafficking once they've exited the NRM, but they are a charity,
Yeah.
and I really do think there is an obligation on the Assembly to provide long-term statutory support for victims.
I think it might be just something that we'll make further inquiries about and get an update in relation to what is the financial arrangements in relation to all of that. Just want to check then if there's any other questions. Doug, okay? I know you're not just waving at me, Doug.
Well, maybe I was just waving at you, mate, to say hello. Listen, Lauren, Rebecca, I mean, thank you very much indeed. I think that's been really, really useful. And just on that 12-month support that you're recommending, and I guess I support that. I think it's absolutely something we should be thinking about and could get behind. Can I just ask you, just for your thoughts on this, what are those people who've been trafficked who, in their mind, and we know it's best for them to return back to where they come from because they want to go back to where they originated from, where they were trafficked from, whatever country that might well be. But if they choose to go back and there's no case pending, for example, that they have to testify on, but they want to go back, they will probably go back to their country of origin with no support. So how do we stop 12 months support being an inducement for them to stay here when actually the best thing for them is to go back to where they come from, if that's what they wanted?
Yeah, that's a great question. I think whenever it comes to providing long-term support, it would be provided in terms of a tailored individual support plan. So you'd be looking at what was best for the individual, what was best for their needs. And yes, you're right, some of them may want to return to their home country, but at the same time, some of them may be fearful to return to their home country because they would be at more risk of being re-trafficked. And ultimately, what we want to see happen is have these confirmed victims set on a stable pathway to recovery, whatever that might look like, because we want to give them the best chance to begin to rebuild their lives, and as Flourish describe it, look towards a brighter future.
And then to that end, then, Rebecca, having been trafficked into the UK, having possibly ended up in our criminal justice system, and then having gone back to their country of origin with no support, but we feel there maybe should be support, is there a case then that the Foreign Office should be also stepping up in order to support those people who have gone back having been trafficked here in the first place?
I think you make an excellent point. I'm going to defer to my colleague Lauren to answer this one, if that's okay.
Well played.
I think it's important to make sure that if somebody was to go back to their own country, that support was in place, that there was conversations that were had to make sure that that victim doesn't slip through the cracks once they've left Northern Ireland. I think ultimately it's about connecting the dots in that instance, what we can provide here, but if they do want to return to their own country, to make sure that they are put in contact with the right organisations that can provide support and step in once they return.
Yeah, thank you, Lauren. Thank you, Rebecca. Chair, thank you.
Thank you. Okay. Just a final check, members. No other member has a question. If not, can I then thank Lauren and Rebecca for their attendance today, for the questions they've answered, for the paper that they've submitted to us, and they certainly have given the committee considerable amount of information to consider. And there are issues that we'll follow up on, which we'll keep you informed then of any responses that we receive. But in the meantime, thank you for your work, and we look forward to continue to work with you. Thank you very much.
Thank you.
I just ask members to take their ease for a couple of minutes. We're not suspending the proceedings, we're just taking our ease, and the reason for that is so that we can prepare the Senate chamber here, because today we have in person a number of presentations. We need to ensure that those doing the oral sessions are safely exited from the room, and also then the room sanitised before our next oral evidence session begins. So if you just bear with us for a couple of minutes. Thank you.
Thank you.
It'll be the first time.
And there'll be a crisis then. Oh dear, I'll be like something I would do. Okay, members, we'll recommence, and thank you for your patience in relation to that. We have the representatives from the Migration Justice Project attending the meeting today to provide the oral evidence in relation to the Justice Sexual Offences and Trafficking Bill. The relevant papers are at page 93 to 111. Can I welcome Liz Griffith, the Senior Research and Policy Officer at the Law Centre of Northern Ireland, Noel Collins, Area Manager, Belfast and Lisburn Women's Aid, Jim Robinson, Founder and Coordinator of Flourish NI, and Orla Gardner, Victims of Slavery Support Services Team Manager at Help to the meeting today. And thank you for being with us. And apologies for the arrangements that we have to put in place. However, in the circumstances that we have to abide by rules, but it's nice to see people in person in presentations and not over a Zoom call, because I think we're all getting to the point where we're zoomed out. But thank you. I think I'm going to invite Liz to briefly outline the key issues in relation to the provisions of the bill, and also to thank you for the paper, which has been extremely useful. Thank you for that, the time that was taken in preparing that for us today.
Thank you. Well, good afternoon, Chair and committee members, and thank you for the invite to come today. It is very nice to be in person here in Stormont. As you heard, my name is Liz Griffith and I work at the Law Centre, and I'm here with my colleague Jill Robinson from Flourish. To my right is Orla Gardner from Migrant Help, and to my left is Noelle Collins from Belfast and Lisbon Women's Aid. And just to give you an idea, Migrant Help and Women's Aid are both contracted by the department to provide support to victims whilst they're going through the NRM, or the National Referral Process, whereas Flourish provides support to victims once they've gone through the process, so post-NRM support, and Flourish assists with long-term integration. Our 4 organisations are all members of the DOJ engagement group, the NGO engagement group on modern slavery, and we would like to thank the department for that regular contact, which we find very useful. So we're here to focus on the 2 clauses of the bill that relate to trafficking, and I would endorse comments from our colleagues at CARE who've already spoken to these clauses. So just to add our support to clause 16, which extends the NRM support to people who have been exploited but not necessarily trafficked. So we're very pleased to see this clause. Secondly, the clause 17, whereby the DOJ moves from an annual to a 3-year strategy. Again, we support that clause. But we do support the proposed amendment whereby the department will publish an annual progress report or check. I think that's very sensible. So, conscious that the title of this bill is Justice, Sexual Offences and Trafficked Victims Bill, but truth be told, there's not much in this bill for victims. So what we would like to do is highlight 3 particular issues, victims-focused issues, to do with access to healthcare, access to financial support, and dealing with historic convictions. My colleagues are each going to set out one of those issues in 2 to 3 minutes, and will identify a possible course of action for this committee to consider. There is a 4th issue which relates to the statutory defence. We don't propose to discuss that right now, but it's in the written report that we submitted. So I'd like to pass to Jill to talk about access to healthcare.
Good afternoon. So I would like to speak about a healthcare entitlement for survivors of trafficking. So currently, while someone's trafficking case is being assessed and they are within the National Referral Mechanism process, there is an exemption which states that most survivors are not charged for healthcare. However, there are a number of instances where individuals receive a negative conclusive decision on their trafficking case, which is subsequently being challenged through due legal process. In such cases, there is no provision within legislation whereby these individuals have access to GP and other healthcare services. The guidance confirms that refused survivors of human trafficking are no longer exempt from health charges. Individuals who have been trafficked are likely to experience multiple physical and mental health risks prior to, during, and after their trafficking experiences, and many suffer acute and long-term health problems. Health consequences of human trafficking may include injuries, physical pain and illnesses, sexual health problems, and mental health problems such as depression, anxiety, and post-traumatic stress disorder. This clearly highlights the critical need to have access to free healthcare, and this should extend to those who are challenging a negative modern slavery decision. We are seeking that the Department agrees a process whereby a refused victim of trafficking who is appealing the decision can access support. Specifically, we wish to propose that the committee seeks a ministerial assurance that she will use discretion available to her under Section 18 of the 2015 Act to ensure that persons with a negative NRM outcome may access healthcare, and that the committee asks officials at the Department of Justice and Health to work together to develop a process for such victims to be registered with their GP. Thank you.
Thank you. I'd now like to ask my colleague Olaf, Migrant Help, to talk about financial support for victims and survivors of human trafficking.
Thank you, Liz. Good afternoon, Chair and committee members here present. It may come as a surprise for committee members that a positive NRM outcome does not in itself give rise to a benefit entitlement. It is a perverse situation whereby some recognised survivors of human trafficking are homeless, destitute and completely reliant on charitable support. Where a person is homeless and has no income, it is almost only a matter of time before they are re-exploited. The main category of affected persons are European nationals who have been granted pre-settled status. They have lawful residence, which makes the situation particularly unthinkable. It's important to note that this situation is not the making of the Department of Justice. Rather, it has arisen due to complex issues, namely the interaction between social security, immigration and trafficking policy. Unfortunately, victims in this jurisdiction are at a disadvantage. There is provision in England, Wales and Scotland to extend NRM support beyond its conclusion. Despite the complexities, we have identified a number of different options, and we would recommend that the committee asks officials at Department of Justice and communities to work with our support organisations to develop a pathway to financial support for all survivors of trafficking. Thank you.
Thank you.
Thank you, Ola. And now I'd ask my colleague Noelle from Belfast and Lisbon Women's Aid to talk about the issue of historic convictions.
Good afternoon, Chair, committee members. Thank you very much for giving me the opportunity to address you here today. I'm speaking to you on behalf of a group of women we are supporting in Women's Aid, all of whom have been given positive, conclusive decisions in regards to their trafficking claims. All of these women are local to Northern Ireland. At a vulnerable time in their lives, they were exploited into prostitution and thus incurred criminal records. It is difficult for many of us to understand the vast impact this has had on their lives. All of them report reoccurring trauma. Most of them have exited prostitution, others are trying. Unlike other jurisdictions, we do not have an exiting from prostitution strategy in Northern Ireland. This responsibility lies with the Department of Health, who are currently putting together an information leaflet. Recent research carried out by UCD, Dr. Monica O'Connor and Ruth Breslin highlights the importance of long-term support in exiting prostitution. The ability to take up employment and feel part of a normal society are crucial. The fact that women with convictions through no fault of their own are being further punished is surely wrong. The women I represent today have cooperated fully with the PSNI and the PPS to bring the perpetrators of these horrendous crimes to justice. They have given statement after statement to strengthen the prosecution's case. Reliving their ordeals over and over again has been extremely traumatic, but they have persevered, hopefully, to a successful outcome. New legislation has been introduced in the south of Ireland, expunging the prosecutions of just over 600 women. This was welcomed by the Garda Síochána, who stated, "As this is no longer an offence, why would women, particularly vulnerable women, be burdened with a legacy and a barrier to other employment? Hindsight is a wonderful thing, and I believe this is something we should have considered in our bill in 2015, which we worked very closely with Lord Morrow on. We're not talking about a large number, but the difference this amendment could make to these women is indescribable. It would be life-changing. We recommend that the committee seeks a ministerial commitment for a time frame for expunging prostitution-related offences. Thank you.
Thank you so much for those very succinct, I have to say, very telling comments that have been made. And also, and it was remiss of me at the start to say a word of thanks. And this is not, I trust, taken as just an empty platitude come from a politician. It is genuinely felt and meant, the work that you do. It is challenging work. And we heard from Claire earlier in relation to Flourish, the work, how much they appreciate the work that you do. And I know that it goes for yourselves, and I've worked closely with Women's Aid in my own constituency, and I couldn't do my work if I didn't have that organisation in my constituency. You're an outstanding work. So a word of thanks and appreciation for what you do. The challenge for us will be taking some of those, whether it's the social security issues, is how we divorce them from this particular bill, or can we find a way of in this bill? And that's a challenge obviously for us. We'll have to maybe should have come with amendments prepared for us, and that would have made our job a bit easier. But thank you for your presentations. Thank you for your help. Just going to go straight to the Deputy Chair, Sinead, and then other members are indicating, and we'll have other members' questions. But Sinead Ennis first, please. Thank you.
Thank you, Chair, and thanks for the presentation and for the information that was provided to us before in the pack. I think my first question was actually going to be on, the expunging of previous convictions for the likes of prostitution in other jurisdictions, like in the south of Ireland or in Britain. But you've actually answered that question. I think you said there were 600 women had previous convictions overturned. Is that right? So that was going to be my first question. Just in terms of the proposed amendment on providing social security entitlement for victims who are recognised victims of trafficking. I think you say in your correspondence that the budgetary implications will be minimal. But do we have an idea just of what they would be? Has that been costed? And just is it within the scope of the bill for the Justice Department to include that? To compel another department, namely communities where social security falls under, to provide for that. Thank you, Chair.
Thank you, Sinead.
Thank you for that question. I think on the issue of financial support for victims and survivors of human trafficking, it is complex. Because of the interaction between immigration and devolved matters. I think we can split the individuals into two categories. Those who are European nationals with pre-settled status, because they have lawful residence, and we calculate that no more than 29 people in this position. I think perhaps a practical approach for these 29 people is an amendment to the Universal Credit regulations, which were to say that a positive NRM outcome constitutes a right to reside for benefit purposes to allow access to universal credit. Just to repeat again, these are people who have lawful residence here because they've applied to the EUS settlement scheme. And they're in a bind because whilst they're in the pre-settled category, they don't have an entitlement. But as soon as they've accrued their 5 years, they will. So really, we're talking a time-limited amount of support, a finite period. So that's how I propose the European nationals, their issues are addressed. For non-European nationals, it is more difficult. But there is scope, I'm confident there is scope within Section 18 of the 2015 Act to provide the long-term financial support, including to people who are who are subject to immigration control. and we calculate no more than 20 people in this position. So we will happily go away and try and do the sums for you as to what the budgetary resource would be, but it's going to be 49 times an annual amount of universal credit, and I can't do that on the top of my head.
Me either. No, that's fine. No, I appreciate that it is minimal, and of course see the merit in it. Just in relation to the healthcare entitlement, because the 2015 legislation covering asylum seekers who are refused asylum but are challenging the decision, are they entitled to a healthcare provision under that 2015 legislation? Would you know?
Thank you for that question. The Law Centre was involved we worked very closely with the Department of Health in 2015 to amend the healthcare regulations to afford an ongoing entitlement to asylum seekers who are challenging a negative asylum decision. So what we would like to see is something equivalent for people who are in the trafficking system who are appealing a negative trafficking decision. And I know that colleagues from Flourish would be able to give you a good example of somebody who is in this category to really demonstrate to you why it's so important. Would that be helpful?
Yes.
Yeah, I'm trying to draw a comparison that there's a precedent in other pieces of legislation.
Yep.
So that's good to know. No, thank you, Chair. Thanks very much.
Sinead. But if you want to give the example, by all means, go ahead, please.
Certainly, this is a gentleman who had received a positive reasonable grounds decision on his trafficking, but a negative conclusive grounds on his trafficking, which is currently being appealed by his solicitor. And the issue arose in relation to when he went to get his COVID vaccine and was unable to do so because he couldn't get re-registered with any GP. And we had contacted BSO and various agencies, and the gentleman does have a health issue which would need ongoing monitoring by a GP, which he then was unable to get.
And is that the case that you referred to earlier when you talked about a legal case?
Yes.
Yes. Okay. All right. Okay. So we'll undoubtedly have some outcome of that at some stage, and hopefully not too soon.
And Chair, if I may just add there, so there is a very clear precedent that has been set in the context of asylum seekers, and I think particularly given an ongoing, the COVID pandemic, for matters of public health, it's so important that everyone has access to healthcare, but also for patient health and for the public purse, because what we see is that, easily manageable conditions such as diabetes or asthma, without regular visits to a GP, they can escalate and they result in much more serious conditions and people going to hospital for A&E, which is much more expensive to the public purse.
Yeah. Okay. Yeah, thank you. Peter Weir?
Yeah, no, thank you. I mean, to some extent I'm covering similar ground. You may be touching on a sort of a very pertinent point with myself, where you mentioned diabetes, having recently been diagnosed and been conscious maybe of the level of involvement there from a health point of view. But to some extent I'm covering maybe similar ground to the Vice Chair. I was really looking, I suppose twofold. First of all, from the presentations that you made, so it's just, I suppose, so that I understand things clearly on that basis. In terms of the areas that you'd raised, it may be that from what you've said, it may be less directly amendments on the face of the bill, but maybe looking very concrete assurances in a very public forum, perhaps in terms of even whenever we're dealing with that, and maybe recommendations from the committee, that it's either a question of the Minister giving assurances, a Minister indicating that particular amendments or changes to legislation will be made, perhaps not necessarily through direct change to the face of the bill, or indeed that perhaps that there will be discretion applied in terms of using existing powers in that regard. So the first question is just to see, to some extent, is my understanding of what you said correct in relation to that it's really, there are the particular areas that you want, and I think make a very strong case for being pushed as regards those with that. And the second point, maybe I'll just ask as well. I mean, again, Sinead had raised the issue, I suppose, trying to establish. I know you'll be coming back to us with some figures in terms of the impact of Northern Ireland on the numbers. Mention was made, I think, particularly, for instance, on the healthcare issue. Of again, it seems to be quite a sensible suggestion of extending the scope not just to those who are in the process, but those who are putting in appeals, for example, that there is still that level of cover that is put in place in terms of that healthcare provision. I wonder, just do you have the figures offhand of the numbers that would be appealing each year, again, so we can judge in terms of what the level of scope of the impact, for instance, of that particular change would be?
Yes, or
Yes.
you,
You're happy for me to?
Yes.
Noel?
So, in relation to providing an entitlement to healthcare and an entitlement to financial support, I think both of those issues could best be addressed through a ministerial assurance. However, for the issue of quashing convictions, I think a legislative change is necessary, and so an amendment to criminal law might be the best option. In response to your to the question about the number of people who currently don't have a healthcare entitlement, it's extremely small. I would be surprised if you would need two hands to count the number of individuals. We think possibly 5 or fewer, very, very small. And again, what is interesting is I think there is scope within Section 18 of the 2015. I feel that the existing powers perhaps haven't been used as fully as they could be.
Okay, Peter.
Yeah, just to clarify, and it may be that, to be honest, we may need to seek just a little bit of advice in relation to this. But in terms of then, and I appreciate the clarification in terms of where you see assurances and where you see amendments. Clearly, for instance, the expunging of previous criminal convictions would require a direct change in legislation. I suppose, and it may be, to be honest, something that takes word. Would you see that change as being, I think there was indication given that, again, though, you would be looking for a direct commitment of the Minister to bring forward changes. That maybe suggests that there would be maybe using a slightly different vehicle to actually have a direct amendment on the face of this legislation. But I don't know whether this legislation, if amended, would actually could provide that or not. Or, I mean, do you have any thoughts on just the vehicle, if you like, for that change to happen?
Okay. So I think a minister, because legislation is needed to bring about the quashing of the convictions, and it's beyond our abilities to propose what that the wording of the amendment. So I think a ministerial assurance that legislation will be brought forward within perhaps a 6-month time scale. We would be very pleased to see that. However, if you would like us to propose the wording of an amendment, we'll do our best to provide that.
I think that what we can do is, in relation to a number of these issues which have arisen, is have a discussion with the Bill Office, which advises us in relation to the scope of the bill, because ultimately there's a process in terms of the scope of the bill, because the Speaker has to determine as to whether or not the amendments are admissible in relation to and in conjunction with the scope of the bill. So I think, on a number of the issues, whether the financial issues or the health issues or whatever, I think that there's a piece of work that we will continue to do to try and get to an understanding of what we can and can't do. I've had experience of ministers in the House in the past giving us written assurances of what would be done, and then in the legislation for that particular piece or department came into existence, they weren't worth the paper they were written on, because the organisation that the legislation was for said it's not in the face of the bill, it's not in the legislation. What Mr. So-and-so said in the Assembly, whether he was Minister or not, in 20 whenever, doesn't. My piece of legislation says that's how I operate. And I think we need to be careful of that and cautious and aware that that is one of the big risks. And that's not to take away the sincerity or integrity of any minister who says whatever they say in the Assembly chamber, but the legislation ties it down. Mm-hmm. So, okay, Peter, you're okay, thank you. Rachel?
Yes, I think Peter's been reading my questions.
Has he?
Yeah.
Over your shoulder. You can see your screen there. Look, he's just behind you.
He is behind me. Scary. No, just I wanted to sort of touch upon the historic convictions, and well, obviously you've outlined that, and with regard to the Republic of Ireland initiative, and obviously that was then that we've seen sort of the numbers of women who've been expunged on that with their convictions, and I suppose I would agree with the chair in terms of on an assurance, and also if there was an assurance that legislation would be brought forward in 6 months, well, we know what's happening in 6 months' time. So I'm mindful just of timing and about how far assurances may go. And again, it's nothing to do with any minister at all. It is just reality of the Assembly mandate and the time. So I would certainly be keen to look at something if there was any way of getting something on the face of a bill, because then it's written down. And whether or not it's commenced, that's a whole different matter, but it's written there, so I'm certainly keen to get things on that. But it would, I suppose just on that is kind of comments on that one. I wanted to talk just very briefly about the healthcare entitlement. Liz, you had said about the Law Centre was involved in amending the healthcare regulations in the 2015 Act, and that was on asylum. What Act was that? Do you know?
I really should know this. The provision of healthcare to persons not ordinarily resident.
Okay, it's
I
probably
can
in your
clarify
submissions.
that for you.
No, what I'm trying to get at, and I think it was the same as the Vice Chair, was that a justice bill or was that a health bill?
No, it was a healthcare bill.
Right, okay. Because that's when we start engaging scope, and I tried that last year with the domestic abuse bill, and just completely fruitless.
It just goes down,
But it doesn't mean that we don't try it. You know, if there's and I think with the licensing bill, we saw some little bit of crossover into health, with talking about addiction and alcohol. So that was something that was a bit of a surprise, but it doesn't mean that it can't happen. So I think it's worthwhile. I raised it with Cara and I as well, and it was on the same grounds of people who are appealing a negative negative decision. If there was an appeal put in and not just healthcare, would you support continuing support in general, like housing and anything else? So it would be a whole kind of support. Yeah, okay. I knew that answer already. What else did I have? I think that's probably all. I think that's probably all for me. There was a number of comments there that had already been dealt with.
If I may respond to that, this could actually be good timing, because the Department of Health is due to revise its operational guidance on its 2015 regulations. So I wonder if there would be an opportunity for this committee to write to the Department of Health and request that guidance makes it clear that entitlement continues after a negative NRM outcome. And then still on the healthcare front, the legislation here on trafficking and healthcare is actually quite similar to that in Scotland. And the way that they're doing it in Scotland is providing a healthcare entitlement through the interpretation of the trafficking legislation. So essentially what happens in Scotland is the trafficking legislation gives their minister a discretion to direct particular services. And I think we could do something similar, and the minister here could direct under Section 18 a healthcare entitlement.
Thank you.
And just procedurally, in terms for ourselves, what our intention is after the presentations today, we'll do, or the staff, Christian will do on our behalf, a scope of all the issues that were raised, and there will be correspondence that we will send to the Justice, to the Minister, but we'll also copy it, for example, in the health issues, copy it in to the Health Committee, because that's the process that we have to have respect to the fact that these are issues which are responsible for the Health Committee and not for ourselves. But that's not to say that we can't raise them. And I think Rachel has made reference to another bill where there was a crossover, and I think it can be done. So that's useful. Sinead Bradley.
Thank you, Chair, and thank you for your presentation so far. Most of the points have been raised, but I suppose I have two further questions I would like to put. In terms of the that appeal period that we've been referring to, when a victim is in appeal and the support that could surround them, I'm just conscious or mindful of the timeline. So could you give me an indication, and I was reassured to hear the small numbers you were talking about in terms of the health, but could you give me an indication as to the timeline an appeal can or should take? And I appreciate some very complex cases may take longer to appeal, but is there a set time frame that an appeal should be completed by? Because I'm conscious of, if we're putting on the face of the bill, be it a 12-month period where there's extended support, would all appeals definitely have been heard and heard fully and not be compromised by that 12-month window? And the second point and question I'd like to raise, in terms of the quashing of criminal convictions, and you make some very present some very clear stories in terms of unfortunate situations, and they're all around prostitution. But are there any other common acts that are other crimes that could or should be considered because of victims of that they maybe are led into typical types of crimes? And I can see how prostitution is an obvious one, but are there any others that we should be mindful of? Thank you.
If I could address the healthcare question in relation to the length of time for an appeal for a negative trafficking decision. Currently, the case that I have referred to was the appeal started in January of this year, and we're still awaiting an outcome of that. So I don't think I can give a definitive answer as to how long it could take.
Sorry, Liz, could I just come in there? I think, there are very there's unidentified times, let's say, for the whole trafficking process. When someone is referred to us as a victim of human trafficking, they come into that 45-day almost investigation. I can tell you now that we are supporting women within our trafficking project that are with us nearly 2 years, and decisions haven't been made on their conclusive grounds. For those who then wish to appeal, it could be a further 2 years, and these people are entirely in limbo because they can't work and, they're not entitled to benefits. I mean, there is something around the length of time of decision making throughout the process. And can I just mention, in relation to the expansion of prostitution prosecutions, that in the south of Ireland we did mention, and some members have mentioned the numbers, it was 607. In Northern Ireland, we don't think it would be any more than 50. So we are talking about small numbers here, because since 2015 it has not been an offence.
Yeah. And on that point that Sinead raised, is there any other activities that could fall under that as well? Because prostitution's one, but there may be other offences that have been carried out that should be considered as well. Liz?
Yeah, so under the 2015 trafficking legislation, Section 22 provides for a statutory defence. Yeah. So where a victim can, where a person can demonstrate that they, were a victim of trafficking, modern slavery, they should not be prosecuted for a certain number of offences. Now, the list of offences that are protected by the statutory defence is much more narrow, that's my reading, compared to in GB. And I think it's about time that we look again at the number of offences, the type of offences that are protected by the statutory defence. To give you an example, when the 2015 Act was being drafted, the type of criminal exploitation we were seeing was people being trafficked here for cannabis-related offences.
Yes.
You know, the cannabis farms.
Yeah.
Sadly, now we're seeing people being trafficked here for distribution of Class A drugs, namely heroin. And in fact, getting people hooked on heroin is the means of control. The way that the traffickers, one of the ways that the traffickers are controlling those who've been trafficked. But our statutory defence does not extend to Class A drug offences. It only applies to Class B drug offences. So one thing that the committee might wish to do is, within the current modern slavery strategy, there is a commitment to review the statutory defence, but I think it's really pressing, and you might wish to ask the department for an update on that, and to look at, you know, is the statutory defence, does it really meet our contemporary understanding of what trafficking looks like, and also, could it not have retrospective effect, which would assist in cases such as the women that Noelle has been speaking about, and other people who've been trafficked, prosecuted for offences prior to the implementation of the statutory defence. And I'm sorry if that was a rather long answer.
No, and as Peter Ware was looking over the shoulder of Rachel, you must have been looking over my shoulder, because I have a note in front of me in relation to that very issue, which I didn't ask earlier to the previous, to the representatives of CARE, and it was all around the issue in regards to the adequacy of Section 22 of the Act, particularly in relation to the Class A drugs issue. So I think that there is something there for us to give, on this bill is making amendments to the 2015 legislation. So there is an issue there. So I would take the view that it's within the scope or the competency of the bill, and I'm not the person who's best placed to answer that. But clearly, I think it gives us scope to consider that. So thank you for that. Just want to check, any other member? Oh, Robin, sorry, apologies, yes.
Yeah,
Robin
sorry.
here. And then if there's anybody else online, if they just indicate. Thank you, Robin.
Okay, Chair, thank you. Thank the members for coming. It's kind of painful reading, to be honest with you. So just two quick questions to Jill. You'd indicated that a case had started in January and still had not been settled at this moment in time. How much of that was impacted by the pandemic situation? Could it have progressed more quickly, or were you not expecting it to progress within that timescale?
I suppose the submissions were made by the solicitor to the single competent authority, so and it depends on, I suppose, how many issues that they're dealing with. We see cases sometimes being dealt with quickly, and some cases, as Noelle also has indicated, can extend for a very long period of time.
Sorry, I should have apologised I was at another meeting before I came down here. Just a very quick question. Are there any under 18s involved in this dreadful situation?
Yes. Yes, sadly, and the number of trafficked minors has increased quite significantly, and they're, thankfully, by virtue of the 2015 Act, all separated minors have an independent guardian to support them, and Bernardo's provide that independent guardianship service, so they would be best placed to speak to you about what's actually happening to those minors. But yes, it's an awful, awful thing that happens.
Sorry, as well as many of the women who come to us would be pregnant as a result of their trafficking and then go on to have these children who they can't identify their fathers with, which puts them, you can imagine, in a situation of what they tell their children when they reach an age of, you know, who is my father. It's a dreadful situation. But many of the traffickers then would, you know, throw the girls out, for want of a better word, once they have become pregnant.
Okay, and then what is the relationship then between the mother and the child in that situation, and the social services and so on?
Well, it's not so much with social service, but mother and child is, you know, women then, you know, we have to take our hats off to them, are wonderful mothers, you know, and hold on to the fact that they have a child of their own and nurture that. I think there are difficulties for women having to, what they tell their children, and we are seeking help for lots of women in relation to that. They don't want to, you know, they could easily tell the child their father's dead, you know, but they don't want to live a lie with their child, so it is looking at the best way for a child to come to terms of where their birthright is.
In terms of the mother who may be involved in whatever type of work, and the relationship between the child and the do the social services not become involved at that stage then?
Certainly for trafficked women, if there are any child protection issues, social services would become involved, but the majority of women who we support who have been rescued through trafficking are no longer in that work.
Okay, thank you, Chair.
Thank you.
Could I say something about family issues? As you can imagine, survivors of human trafficking, you know, they have family members in different parts of the world, or sometimes family members in Europe. And due to, as a result of Brexit, the possibility to reunite families, those avenues have now diminished very, very significantly. And so what we're seeing is people here who get recognised as survivors of human trafficking, and yet, you know, their children, often their children, are stranded somewhere in a refugee camp, never quite made it for whatever reason. And we didn't include this in our brief to you because we recognise that this is really, you know, family reunion issues sit with Westminster. But, you know, I can't really just explain to you how difficult it is for survivors of human trafficking to really integrate in society here when they have teenage daughters stuck somewhere en route here. And all the three organisations here are working with women and men in this position now. Had they arrived a year earlier, they would have had access to family reunion rights. Those rights no longer exist.
Chair,
yes,
I mean, I know you say it's a Westminster issue, but in terms of information, I think I would appreciate, Chair, I'm sure the other members of the committee would, some paragraphs on the issue. I think that would be, I think that's something all of us would be concerned about.
Thank you.
Sorry, on a happy note, if there is a happy note, we reconciled a mother and daughter this morning who had been separated for 5 years, and both have turned up in Northern Ireland. So it was a very happy occasion for both of them.
Very good. And a word of appreciation to you all who were involved in that. So thank you for that. Just want to check if there's no other questions of members in relation to this. Okay, just one question I have to conclude, and it's really in relation to the support or otherwise for the provision for the introduction of the slavery and trafficking risk orders. Would you be in favour of their introduction?
We discussed this as we were coming
and
in.
If you want to not give us an answer to that today, but think about it and correspond with us.
Yes.
Because because that's trying to be fair.
Yes.
Because I don't want, and I appreciate because you are a number of organisations. Mm-hmm. So maybe that's the fairest way. If you want to leave it that way.
Agreed.
I'm trying to be diplomatic here. Don't like me.
We'd be very happy to follow up.
Okay, thank you. And we'll await for that at some stage. But in the meantime, thank you. And I have to say, I think we've To say enjoy is not the right word, because we are dealing here with individuals. We're dealing with real people who have real lives and they have awful experiences. So, and I know that your organisation's endeavours to try and make their time here as best as they can, but the system, the processes and the paperwork and the hurdles and the obstruction and all of that makes it all very, very challenging. So thank you for your submission, and we have a considerable amount of work to do in relation to this bill, but that's what we're here for, and we look forward to continue to engage with you. Thank you very much.
Thank you very much.
Thank you very much.
Okay, members, the same as before. We'll just take a ease for a few minutes until our guests leave, and then our next presentation will come in. So thank you for your help in relation to that.
Thank you all.
Thank you.
Bye so much.
Thank you. Bye-bye. Tough job. Tough job. Flourish is a very See that? Care, do you have it from? No. See that asylum, so. Turn. Very good. Very good. Oh, it is. You're in for a number of long nights, I think, with the Justice Bill. Look at hotel room in Bangor, I think. Okay, members, we will recommence. Thank you for your help in terms of trying to get ourselves in a safe place here in the chamber. So I welcome representatives from NSPCC and Bernardo's who are attending today to give evidence on the bill. You're very welcome. Thank you for and apologies if we've kept you longer than you maybe anticipated. So thank you for being here. And we'll just ask you to make your presentations, and then members will have undoubtedly questions. Thank you for your time with us today. And thank you for the work that you do, and also for the submission that you've already given us. So thank you.
Thanks very much for inviting us to address the committee today. We're really grateful for the opportunity to be here, and we really welcome the bill. and we hope that our input today is useful to you in your consideration of the bill. We welcome the introduction of the upskirting and down-blousing at Clause 1 of the bill. We would welcome the committee given consideration to the motive requirements beyond sexual gratification or to humiliate, alarm or distress the subject of the taking or recording of images or video. These issues are currently being considered in the Law Commission in England and Wales's consultation on intimate image abuse. Also, we would be supportive of an amendment to the additional voyeurism offences to include threats to share images where there is an intention to cause fear that these threats will be acted upon. Clause 2 creates 4 new offences regarding adults masquerading as a child. We fully support the intention of the new offences to disrupt grooming or other offences earlier where this behaviour would indicate a risk to children. We are, however, challenged as to how it will be proved in practice that someone is communicating with a child with the intention of subsequently committing an offence. Clause 3 covers miscellaneous amendments as to sexual offences. We strongly support the proposed removal of legislative references to prostitute, prostitution and pornography, which misrepresent the abuse and harm that occurs to children in these contexts. While the bill does not propose to make any further changes to the law in this area, we believe that the definition of payment in the context of these offences should be considered by the committee. CSE cases often involve complex dynamics between a victim and perpetrator and may involve intangible forms of exchange, reward or inducement, such as affection or protection for the victim. We believe that the definition of payments should be extended to include other inducements to ensure that it is in line with regional cooperating to safeguard children guidance and broad enough to capture the wide range of cases of CSE. Clauses 4 to 14 deal with anonymity and privacy, and again, we're supportive of these provisions, which should strengthen protections for complainants and encourage more victims to report abuse and seek support. Clause 15 proposes to exclude the public from the court in serious sexual offence cases. We would like to see this provision going further to offer greater protection to child victims and their families, and recommend that the committee considers extending exclusion from proceedings to all sexual offence cases involving a child, whether these are tried in the Crown or Magistrates' Court. We believe that this is necessary to protect the privacy and anonymity of children, and we do not believe that allowing members of the public to view sexual offence court proceedings involving a child is in the child's best interests. With regard to the planned amendments to the bill, we welcome the abolition of the rough sex defence, which will outlaw the use of consent as a defence to serious harm for sexual gratification. We also support the proposed extension to existing revenge porn provisions to include making a threat of publication with the intent to cause distress and offence. We warmly welcome the proposed amendment to widen the scope of the current law on abuse of trust to strengthen protections for 16 and 17-year-olds in non-statutory settings. Currently, it is illegal for individuals only within defined statutory roles to engage in sexual activity with a 16 or 17-year-old under their supervision. NSPCC has campaigned for many years for the extension of the position of trust offences to include all adults in positions of power and authority over children aged 16 and 17, regardless of the setting. We are therefore disappointed to learn that it is intended to extend the abuse of trust offences to cover adults in sport and religious settings only, with a delegated power to enable extension of those settings at a future stage should it be considered necessary. This position replicates the proposed legislative amendment in England and Wales under the Police, Crime, Sentencing and Courts Bill. If this approach is taken in Northern Ireland, adults working in non-statutory settings in a position of trust to a 16 and 17-year-old in areas other than religion and sport will remain outside of the law. This conflicts with views expressed in the Department's public consultation on CSE law in February 2019 and in the joint stakeholder workshop NSPCC facilitated with the Department in May 2021, where respondents overwhelmingly supported an inclusive approach to legislative change which should include all adults working in a position of trust to a child. There is also considerable ambiguity about the scope of the amendment if this is religion and sport settings only. It is unclear what specific activities will be included within the definition and could lead to a range of bizarre scenarios where, for example, a 16 or 17-year-old may be protected while engaging in a dance or drama class only if the class is connected or possibly carried out on the premises of a sporting or religious organisation. This is a considerable gap in protection for young people and creates unnecessary legal uncertainty. In addition, it's unclear if organisations with a religious ethos would be included within the amendment, for example, uniformed bodies such as scouts, guides, cadets, etc. While we have not had sight of the drafted amendment, we would recommend that consideration is given to the inclusion of hobby or extracurricular activity in addition to sport and religious settings, with a list of activities detailed in guidance. This would ensure that the provision is broad enough to capture a wider range of settings where adults have influence and power over children, and to ensure that there's enough clarity and certainty in its application. The proposed further expansion of protection enabled by the power to add or remove fields of activity by way of affirmative instrument is welcome. To further strengthen and future-proof the provision, consideration should also be given to the inclusion of a statutory review mechanism. One additional area in need of urgent legal reform in Northern Ireland not addressed in this bill is the removal of the defence of reasonable punishment to afford children equal protection from assault as adults. In Northern Ireland, the law provides for a defence of reasonable punishment for parents and carers accused of assault against a child. It is our view that this is a key public protection issue, and we would support the removal of the defence being brought forward as an amendment to this bill. A wealth of research shows that the use of physical punishment is ineffective in changing the behaviour of children in the long term and can be extremely damaging for children's development. A 2015 international literature review found strong evidence that physical punishment increases aggression, antisocial behaviour, depression and anxiety in children, which may continue long into their adult lives. Harsh forms of discipline and physical forms of abuse in particular can have long-lasting impacts on future behaviour and mental health. Research from Harvard University in 2020 found that physical punishment experienced by very young children predicted reductions in cognitive development. Physical punishment is also among a range of important risk factors for child physical abuse. Most physical abuse starts out as physical punishment in the attempt to correct misbehaviour, where the punishment escalates in force and intensity. There is evidence that the removal of the legal defence is associated with accelerated declines in the prevalence of physical punishment, as well as reductions in severe physical abuse. This is particularly pertinent for Northern Ireland, where physical abuse is the main reason for a child or young person being placed on the Northern Ireland Child Protection Register. 31% of children on the Child Protection Register are on the Child Protection Register due to physical abuse. We need to take urgent action to protect our children from abuse, and legal change is a vital part of that. A change to the law on physical punishment in Northern Ireland is solely about protecting children and keeping them safe from harm. Widespread criminalisation of parents has not been the effect in any of the countries that have passed similar laws. If the defence of reasonable punishment was to be removed, accusations of assault against a child would be investigated by the police and social services exactly as they are now, and the thresholds for intervention would not change. The removal of the defence of reasonable punishment in Northern Ireland would lead to better public protection and better legal protections from children from the extremely damaging effects of physical punishment. Thank you.
So thank you, Chair, and thank you to the committee for having us here today. My name is Trassa Canavan, and I'm the Senior Policy and Public Affairs Lead for Barnardos Northern Ireland. Just to give you a bit of background on Barnardos, we are the largest children's charity in Northern Ireland, and in the last year we supported over 18,000 children, young people and families right throughout Northern Ireland in more than 45 different services and programmes. And the evidence that we submitted to the committee in writing, and also that I'll share with you here today, is informed by our experience supporting children and young people who've experienced abuse. For example, our regional service SEEN, which stands for Sexual Exploitation Ends Now, is a specialist child sexual exploitation service which supports children, young people and families affected by or at risk of child sexual exploitation, and can provide specialist therapeutic support for children who've experienced sexual exploitation. We also deliver universal early intervention and prevention programmes like our Life Skills programme, and that's going to be really important when we think about the implementation of this bill and what sits alongside that. So our life skills programme is universal, it's highly effective, and it's early intervention and prevention. So it's delivered in classrooms to children aged 8 to 14. It's capacity building, so we train teachers to deliver this to their classrooms. And year after year, research has shown that it's highly effective and evidence-based in changing behaviour and attitudes in children. Looking at this bill, we very much welcome this bill and the intention of the bill, and in particular this committee's scrutiny of the bill. This is a really important piece of child protection legislation, and it seeks to address a number of gaps in our current legislation. Our main concern in relation to this bill is how usable it is in practice, and this will be a theme that I'll return throughout my evidence, and that's that a bill or an act is only words on a page until we put it into practice. And if the provisions in this bill are unusable as they're currently drafted, then they are just words despite the very best of intentions. And we're concerned about that in this bill with a number of proposals, and that's what I'll focus on now. So that would be in relation to Clause 1, which is the voyeurism offence, Clause 2, sexual grooming pretending to be a child, and Clause 3, which is the definition of payment regarding child abuse and exploitation. And this concern around usability is most prominent when looking at Clause 1 and 2. So we very much welcome the creation of these new offences of upskirting and downblousing and adult masquerading as a child, but we're very concerned about how the offences are framed in the bill and the burden to prove the intent of the perpetrator. We're concerned that as they're currently framed in the bill, the offences will only function as add-ons whenever a person has already committed a crime of a much more serious nature, and really that behaviour is discovered retrospectively. If that's the case, if that's how this bill is intended, then it's not about child protection anymore, it's about lengthening sentences and punishments. In order to actually protect children, this legislation needs to be usable when the initial offence has been committed and before it escalates to become more serious harm. We're also concerned about the proposed definition of payment in Clause 3 regarding child abuse and exploitation. It's too narrow and it does not reflect the reality of exploitation here in Northern Ireland today. The proposed definition focuses purely on transactional payment rather than the intangible exchange of meeting emotional, protection or attachment needs in the victim, which in our experience here is much more prevalent. Finally, we would strongly encourage the committee to consider the amendments to the bill in relation to equal protection and abuse of trust, and I think Natalie's given a really great rundown of those. I would just add that it's vital that children in Northern Ireland are afforded the same protection as their peers elsewhere in the UK, and this bill provides the opportunity for this Assembly to do just that. And again, we understand the Department are drafting these amendments, and we'd welcome the committee's scrutiny of that. While we also have not had sight of those amendments, we would really encourage that amendment to be as broad as possible. Don't limit it to religious and sporting organisations. Instead, we need to focus on the relationship and position of trust that the adult holds, rather than their title or the category of their organisation. So that concludes my comments, and I welcome any questions that members might have. Thank you.
Okay, thank you. Is that all we have in terms of presentation? Just in terms of the issue that was raised by NSPCC, the Close the Loophole campaign. Has there been discussions with yourselves and the department in relation to that?
Yeah, we've been working very closely with the department in relation to this. It's something that we've been working on for a number of years, and we've been trying to get the law changed for some time. It's a gap in the law which we know that the department have said that they want to change. And I suppose we are aware that the department, I don't want to be too critical of the Department of Justice because actually they have a very full legislative time frame.
As we know.
Yes, as you are much more aware of than me. But I suppose in light of the fact that we saw an opportunity to bring forward the amendment within this bill, we had discussions with the department about why they felt that it couldn't be brought forward within this mandate. And they cited rightly capacity. So we have been working closely with the department in partnership to try to build their capacity to help as much as we can. So we jointly facilitated a workshop with the department in May 2021. Where there was a broad discussion with a range of organisations about the need for legislative reform and what that should look like in Northern Ireland. We also got a pro bono legal opinion which we shared with the department about the best way to do this in Northern Ireland to make it as inclusive as possible, which was their intention, we know, at one stage, but that appears to have changed and we now appear to be going down the same sort of route as in England. And that causes us concern because, as I've said in my presentation and in our evidence to the committee, it doesn't go as wide as it should do, and it's also very unclear about who will be captured. And our concern is that some organisations who should be captured within the legislation perhaps won't even be aware of the fact that they will be captured or not. And it will give rise to these sorts of scenarios which we outlined, where if something is happening that is connected to religion or sport, that a 16 or 17-year-old will be protected, but they may not be protected if it's not. So we think that it's very unclear. It brings about legal uncertainty, and it's an area that we would very much like to see the department extending to include all adults in a position of trust to a child, regardless of the setting.
And I know this is an unfair question because, and I appreciate the relationship between yourselves and the department, and we have a scrutiny role of the department. But in terms of, have you any sense as to why, having given some indication that there was a road of travel that you thought they were going to take, then when you see the detail of the bill, it doesn't reflect that? Do you get any sense as to why that was the case?
I'm not sure. I think there might be a nervousness about it going too broad with the legislation, but I mean, there are lots of examples from elsewhere where this has been done and has been done in an inclusive manner. So it's been done in Jersey in quite an inclusive way. It's also been done in the Republic of Ireland in a much more inclusive way where settings haven't been stipulated. So I suppose for us, the other thing to say as well is that in England and Wales, and I think we've referred to this in our written evidence, but in England and Wales there is a lot of discussion ongoing about the sport and religion definition, and there has been an amendment proposed by Sarah Champion MP to extend that out, and that's actually going through at the moment. I don't know whether that will be successful or not, but certainly it's one that we are watching with interest, and our colleagues in NSPCC in England and Wales are working on. But it is something that we feel, unless we take this opportunity to do this right from the outset, it is one we're going to have to come back to in the future, and we would very much like to see it being done as inclusively as possible, because there will be children for whom they require these protections, and if they can't get those protections from the outset, harm can happen. And I am very nervous that NSPCC wouldn't be supportive of the wait and see mentality, that if we can collect evidence that abuse does happen in these settings, then we'll change the law. Abusers will familiarise themselves with where they can and where they are outside the law, really, and that's our concern. We'd like to see as robust a set of protections in place from the outset as possible.
And just a final question for me, and then we'll go to members. But in terms of, you had mentioned that a definition, but then listed in guidance. Is there the risk that if you haven't the definition right, the guidance also doesn't cover everybody? So that there, it's how do you get something which is all encompassing? Well, and that, because kit lawyers are always able to find a way of ensuring that they can navigate a piece of legislation. So how do you, and maybe is that part of the nervousness of the department in relation to, and I'm not trying to defend the department here, I'm just trying for us as a committee to get a sense of what would that all-encompassing piece or line look like in terms of the legislation.
I suppose you could be right. I'm not entirely sure, but I do think that we're sort of what we are proposing is a bit of a belt and braces approach, if you like. So what we're proposing is that there is the consideration of the addition of hobby or extracurricular activity, which could include all of those other activities such as dance, drama, music, etc., private tuition, and then there is the list of activities is outlined in guidance. We are also proposing, though, that the further expansion of the protection by way of affirmative instrument, which we know the Department is proposing to do already, which means that that could be added to in terms of additional settings. So if we had sport, religion, extracurricular activity and hobby, for example, there could be a list of activities and guidance, but if there was a gap that was identified down the line, that could be amended and future-proofed in the way that the Department is proposing to do already. So we would hope that that would be as all-encompassing as possible, really. It's always difficult to legislate for every eventuality, but this is how we would be proposing that you would get it, as I suppose, as close as we could propose.
If I could add to that. Also, I think it would be very helpful if the Department was to share the proposals that they have for the amendment, so then we can actually scrutinise that and have a look to see whether we think that it needs to be tweaked here or there, because you're absolutely right. If we get it wrong in the legislation, then there will be problems with the implementation, so let's get it as soon as possible, scrutinise it and get it right.
Okay, we'll go to, and thank you for those answers. We'll go to Sinead Bradley and then Rachel.
Thank you, Chair, and I genuinely thank you for your written submission and your presentation today, because there's plenty in there, and I suppose we could keep you going through each individual clause as you have done in terms of your thoughts and suggestions. And based on that clause 1, the voyeurism piece, you mentioned about widening that to include just for a bit of fun or for a laugh. And I suppose it got me thinking then, when it's widened to that parameter, are we, whilst then we're trying to, I suppose, list or capture all the scenarios, would you suggest that by going that wide, we're actually saying there would be no circumstance where somebody would be capturing an image upskirting or down blousing? Because I'm struggling to think beyond just a bit of fun or laugh. What else could possibly be used in that scenario? So it's just a thought. Any comment you would have on it? And in terms then of the pretending to be a child, I wasn't clear if you're actually alluding to there being a lesser offence, because I think you make your point very well about this being a piece of legislation that is trying to avoid the exploitation actually happening. So it's about early intervention. And I just wondered, is that what you're actually alluding to? You refer to, I think, a layer. I haven't got it quite in front of me. Layered offence. So just a little bit further explanation on that, if possible. Thank you.
I suppose I'll have a go at answering that. So in relation to clause 1, I suppose NSPCC's position is a bit different, I think, in that we are concerned about the limited scope of the intentions, where they're problematic, I suppose, from the perspective of victims' rights. The two-pronged approach that is being proposed in the bill at the minute to cover sexual gratification or to humiliate, alarm or distress a person who is the subject of the image or the recording may not capture the full range of perpetrator behaviours or motivations. Taking a non-consensual intimate image is deeply upsetting for victims regardless of the intent. But that's not to say that we are firm on our position around what the intent should include. What we would advise really is the Law Commission in England and Wales have just carried out a consultation on intimate image abuse, and it closed in May. They considered whether the offence should focus on the lack of consent and other potential motivations. The upskirting offence, which mirrors the upskirting offence which we are talking about today in England and Wales, it was introduced in England in 2019. The consultation considered limitations and gaps in the law. I suppose I would encourage the committee to engage with the Law Commission and to take cognizance of the early findings from that consultation exercise to ensure that we are legislating in line with the valuable learning from that, especially given how closely linked the two offences are. It's also unclear to us from the proposed motivations whether an image to intimidate, silence or extend power over a victim would be captured by the proposed intention to humiliate, alarm or distress. And I suppose if it's not captured, we would support the intention to exert control or power being added to that. But certainly we do think that there is a lot of learning that could be gleaned from the Law Commission's consultation, and it might be worth just linking in with them to see what kinds of issues have been raised in the consultation exercise. The other point, Sinead, that you make around Clause 2 in relation to the sexual grooming, we are hugely supportive of this, the intention around the introduction of these 4 new offences. We very much welcome the intention to better protect children and address and disrupt grooming and other behaviour where it would indicate a risk to children much earlier. The challenge for us really is how you prove this in practice. So how do you prove that someone is communicating with a child with the intention of subsequently committing an offence? Now, we are certainly not the experts on that. We have discussed it with the department, and we understand that these issues are being explored by law enforcement, including the PSNI. So I'm assuming that they have the answer to how you would do that. So, and it's really welcome that the Minister is leading the way in closing a gap that has emerged in practice, which will lead to better protection for children. But we would take our steer from law enforcement and hope that the operational elements of this can be worked through and will be worked through, but would certainly caution that the law be kept under review to allow practice to inform any changes that would be needed.
If I could, yes, come in on that. I suppose, going back to Clause 1, I think that whenever you say, is there any kind of circumstance that wouldn't be captured under this bill, I don't know why someone would need to take a picture of someone's skirt without their consent. So broadening this definition is something that we are supportive of. Very concerned about how you would prove that they intended to humiliate, they intended to alarm. How do you prove that they intended to get sexual gratification from this? I don't know how usable that is in practice, and this is our real concern here. If they do it, they just say, oh, it was for a laugh, it was for a joke, or X, Y, or Z. And once we start narrowing that scope, it becomes something that's just words on a page again. So that's where we are at, and I suppose the line that I would say is that the impact of the offence on the victim isn't dictated by the intentions of the perpetrator. Yeah. Then moving on to Clause 2 about sexual grooming and pretending to be a child, where we sit on that is that again, how do you prove that a perpetrator intended to groom someone? I don't imagine they wrote it down on a page, so we can't see what's inside their head, and that's not going to be very difficult to prove. How I would imagine this would be used would be once they had escalated this to become sexual grooming, then they've already graduated into a more serious offence. Retrospectively, you could look and go, oh, back then and kind of 6 months ago they were talking to them and there was no sexual grooming, so we'll add on that offence of with intent to groom because they later went on to do it. But in actual fact, what reason do we have for an adult to masquerade as a child? And that's been sitting with me since this bill was published. I can't think of a good reason as to why an adult needs to masquerade as a child that's more important than child protection. So why have we created this burden that the PPS and the PSNI must start to gather evidence that they intended to groom? And I don't even know, as I say, what in practice does that evidence look like? What can they put before a judge where they can say, I've met that burden of proof for you? So that's where our major concern with this offence is. And we absolutely welcome the intention. Let's get in early, let's stop grooming. But I don't think this offence, as currently framed, does that.
Sinead, you happy enough?
Yeah, I really do appreciate that contribution, because I see where you're coming from in terms of that burden of proof and the intent. It's clear as mud, to be quite frank, when you start to consider operationally how it does roll out. But I think it's equally as challenging to say then, how do we actually put words on a page that are broad enough to remove that burden, but not so broad that they equally become just non-operational? But it certainly is a challenge, and I genuinely appreciate it being brought to our attention. Thank you.
Thank you. Just before we go to Rachel, in relation to the amendments, we've asked for the department. As soon as we get them, we will share them.
Fantastic. Thank you very much.
All right. So just that will be hopefully helpful. Rachel.
Thank you, Chair. I can't agree more. Why would there be an instance where an adult would need to pretend to be a child? don't understand. It's never sat well with me since we looked at it as well over the summer. And it's the same then with clause 1 and the for the laugh, which is sort of called it as a defence. And I raised this at second stage, and I don't think it's covered. I think that is a defence that could be used, and how do you prove that? And it's the same then in clause 2. So I think there certainly needs to be clarification on both of those. And if there was any, other potential purposes that we need to capture within the scope of the offence, would you support an amendment coming forward to clauses 1 and 2 for those specific issues? In terms of clause 2 then, have you had any discussion with the department about what effect it would have to remove the requirement for the offence to have the purpose of grooming, and raising those, if there was any unintended consequences, say if we simply criminalised an adult to pretend to be a child, and that being the behaviour in and of itself?
We have had some discussions with the department about this. As I said, it is one that we have concerns about in terms of how this is going to be operationalised. The department at that point shared our concerns and said that they were talking to the PSNI, who assured them that these operational elements could be resolved. I suppose one of the issues for us, well, I suppose that this came out of the conversation that we had with the department, was that would there be a possibility of a parent being online and pretending to be an adult in order to protect their child? Now, I'm not sure if that would ever arise, or if there would be a child protection consideration for someone to pretend to be an adult, but it's not actually as straightforward as it might appear, I think, and that's why we would be a bit more sort of reticent about saying you should remove it entirely. It's certainly one that I do think merits a much broader discussion, because I'm not sure how it'll be operationalised. And when I read the bill, my first reading of it, that was the thing that struck me, was how do you prove intention? And I would be concerned that it would end up being an additional offence after the other offences have taken place. And that it would fail in its intention to disrupt grooming as early as we would hope. But there may well be scenarios that we haven't thought about, and that the department are aware of, and I would very much welcome being part of a sort of broader discussion around that to make sure that its intent can be fulfilled.
If I could just
just on that one is in my head before I forget, but just sort of an operational for us, and to let yourselves know, we intend to bring the police at the end of these presentations, and we'll have supplied the police with all the submissions and also the Hansard records of this, so that, because it is the one thing that comes up time and time again. There's no point of us going out and saying, oh look, we've passed this piece of legislation, it's not worth the paper it's written on. Operationally, if it cannot intend or carry through what its intent is, but if the intent even is questionable, then you've got to ask serious questions. Are we doing the right thing here? Everybody accepts that there are certain things in this legislation that we say should not be happening. Upskirt and down blouse and grooming.
Yep.
Shouldn't be happening. And the point that Rachel makes, why should any male or female want to pose as an adult or as a child? Why? What? So that you know that that's what we'll be doing, and those questions will be put to the police, because we want to be absolutely sure that if this is the legislation, the people who are engaged in these activities will be able to face prosecution. Sorry, Rachel, but you're going to make a comment.
Yes, and I really, really welcome that, and I think that I'm really interested to hear what the PSNI have to say. I'm not sure whether it's also planned, but the PPS, what information will they be looking for to bring a case forward, and what would they say? Oh yes,
they're coming as well.
Perfect, brilliant. In terms of the kind of situation that Natalie was floating there, and this is something that we've talked about ourselves, about maybe a parent trying to check what's happening with the child, there's actually a major concern there, which is that if you look at the case that I linked in our written evidence, it was a young person that was groomed online, and of course it didn't escalate to sexual grooming until the trust had been established, and actually in that case it did go on to become physical contact and everything that is awful that you can imagine would happen. But initially they were able to establish that trust and that contact because that person was a parent themselves. and they had children who they could understand how kids talk, what conversation they might be having, what things might they be interested in. So when we start to say, oh, well, maybe we let parents do it, in fact, we know the perpetrators look for loopholes. That's how they operate. So that would be a loophole. And I would say as well, there might be cases where a parent genuinely wants to find out, then it wouldn't be in the public interest for the PPS to take forward a case where clearly the evidence can show that parent just logged on and was trying to check in on their child. That should be quite a clear case to prove. However, if you've got a parent who's going on and talking to other children who are not in contact with their child and having conversations, that's where we've got to have questions. Why are they doing that? So I think that we need to really strengthen this offence, and I would really welcome PS and PPS comments on this.
Thank you. Can't agree more, to be honest. Just in terms of the abuse of trust, then, and Natalie, you mentioned about the Republic of Ireland and it up in Jersey as well, and I can't remember off the top of my head, sorry if this was covered. When did they come in? Are they relatively recent pieces of legislation?
I'd have to check that, Rachel, or defer to my colleague.
Republic of Ireland was 2017 and Jersey was 2018.
Thank you, Orla.
Thank you very much. And since that has come in, are you aware of any significant challenge to this, to having the abuse of trust wider than just sports and religion, or issues with this? Have they been raised, or is that something that's coming through?
No, we're not aware of any major challenges at all. We know that it can operate. I mean, it's not just those two regions. We did provide a briefing paper in June to the committee, which sort of gave an overview, which I could resend again, but just an overview of all the sort of legislative positions and how they were operating. In Jersey, one of the drawbacks is that it wasn't very well publicised. We don't know how well it's going is the problem, but we have had conversations with officials from Jersey, and they assure us that there are no major problems with extending it out. But as I say, that it's all explained in a bit more detail in that briefing paper we've provided in June, where we look at sort of other areas and how it's been done in various areas, just to give the committee a range of legislative options that you could consider to make it as inclusive as possible.
Jersey's so small, everybody would know anyway.
Yeah, they would just talk to each other.
And finally, just on this abuse of trust, guidance will obviously be a big issue and a need for guidance as a huge part of rolling abuse of trust and getting people understanding what that means. In terms of what you said about Jersey with the public publishing and people knowing about it. So would you support the department having to issue guidance and public awareness on abuse of trust in conjunction, obviously, then with other departments? You know, education's going to be huge here. Yeah. Communities and so on.
Yeah, no, absolutely. We think on the positions of trust there's certainly going to be a need for guidance and education, but that's actually going to be the same for everything in this bill. And upskirting and downblousing being another area where we're going to need very specific guidance, because certainly since not to detract from positions of trust, but since the offence came in England in 2019, we know that there have been a number of instances of upskirting in schools. And so we're absolutely going to need clear guidance for schools as well around how this operates. But we're going to need a public education campaign for young people, because young people are going to need to be aware of the consequences of these sorts of actions. And part and parcel of that is good quality RSE. And we always come back to RSE, but ultimately we need to educate children about the types of behaviour that's expected, what the consequences are, what criminal offences are, you know, and ultimately that is a huge gap. And I will continue to raise RSE in every context, but in terms of guidance, yes, and we would be more than happy to help the department and in any way that we can, as we have done from the outset around positions of trust and all of these areas, to contribute in any way that we can to the development of that guidance and any public awareness campaigns. But yes, they're absolutely necessary.
Thank you. I can't agree more on RSE. I, like you, would be raising it at every single opportunity. We've been dealing with various new offences and changes to justice legislation in the last year and a half, and that we keep coming back to the need for comprehensive mandatory RSE for children and young people, let alone adults, on what a healthy relationship is and what what's the consequences of actions and what you should and shouldn't be doing. So finally, and I want to touch on both of you with equal protection. I think it's an absolute shame that we don't have this in Northern Ireland. It is an absolute disgrace. If we are going to take children's rights seriously, if we're going to talk about ACEs, being trauma informed, and all of those things that we all like to talk about, that is the kind of action that we need to be doing. That really should be in this bill. And I know it is touched upon in the submission, but it's an argument that does keep coming back, and it's about the potential to criminalise parents and criminalising family and criminalising the home. It's not an argument that I buy, but it is one that I think we need to discuss. Could you go into that a wee bit more, maybe just on the effect that that hasn't happened in other jurisdictions, and sort of how is that countered?
Yeah, I mean, I think I mentioned this in our written evidence, but the first English-speaking country to ban physical punishment in 2007 was New Zealand. And there it was carefully monitored because of course that is a concern, and that isn't what anybody who is asking for the removal of the defence around equal protection really is talking about. What we're talking about is we want to change social norms, we want to move things along culturally, and we've seen how legislation can have a really powerful impact in changing public attitudes and social norms. I mean, if you think about seatbelts in cars and you think about the smoking ban, I mean, all of a sudden people try to comply with the law. That's how we work. We're generally law-abiding citizens. So in New Zealand, they monitored this very closely from 2007 to 2012, and there were 8 prosecutions over that course of those 5 years. And the police the police chief, I think it was, said that parents had not been prosecuted for smacking, and that there had been no change in the reporting of smacking since the law was enacted. This is not about criminalising parents. We're not looking to, and certainly that's not in the child's best interests either. It's not in the family's best interests. This is about the promotion of non-violent means of parenting children. And certainly one of the things that we think needs to accompany a change in the law is a focus on positive parenting and a public education campaign about how to parent children in a way that isn't detrimental to their mental health long term, that will work and is effective in changing their behaviour. So I suppose, there hasn't been that widespread criminalisation of children. That's certainly not what we're advocating for here. Interventions would operate in exactly as the way they do now. The police, in cases of assault against a child, social services interventions and police interventions would not change. And that is something that we would be very firm on. If there were concerns around parents assaulting their children, we would very much be advocating for a protective welfare approach, so that there could be an intervention whereby those parents are supported to find alternative means of disciplining their children. But certainly, the evidence shows that there has been, that it is one of the key risk factors for physical abuse, and that's something that we are really, really concerned about. If we can legislate to try to prevent physical abuse from happening in the future, we have to do that. I think there's an onus on us to do that. And I know that it's a controversial issue in a Northern Ireland context, but we have to protect our children, and particularly given what we've seen in terms of COVID and the rise in all kinds of abuse, the rise in accidental deaths in relation to babies in England. We have absolutely, now is the time that we absolutely have to act, and I think that I speak for the children's sector whenever I make that call.
Rachel, would you allow me to come in just on that point? Sorry, you'd mentioned in Bernardo's, particularly on 7/6, where you talked about a campaign in Wales, an awareness-raising campaign in Wales, and it was launched by the Welsh Government, high-profile multimedia campaign. Do you want to say something about that?
Yes, so basically I think that the concern anywhere that this is brought in is that there is going to be a criminalisation of parents. So in order to counteract that, it's about raising awareness before the offence actually, the change in the law comes into place. So in Wales, what they've done is that the change in the law, I believe, comes into effect in March. So they have started this really big campaign, and I've talked to colleagues in Wales, and you kind of see it on buses, you see it on social media, you see it on all these different places, to make people aware that this is a change in the law. And this is absolutely not about criminalised parents. In fact, we hope that no parent is ever criminalised under this. I think it's really important to point out that we have a very clear line when it comes to assault. You can't assault someone. But what we've done with children is we've said you can't assault them, but there's a defence here that you can use. And so we've just blurred that line, and we've made it so that actually our most vulnerable citizens in our society, the people who we should be helping the most, have got this blurry line around assault. So by clearing that up, by making sure that they have the same protection here in Northern Ireland as the rest of the UK, but also as adults have from assault, then we're making sure that everyone is on a level playing field, and then we just bring parents along with us. We have fantastic parenting programs that show you how to you can engage with your children, that you build a really strong and healthy relationship, secure attachment, all of those things, and that begins on day one. In fact, it actually begins before day one, but we can do that, and lots of parents are doing that. And I think that, especially if it's something that you grew up with yourself, sometimes there's this attitude of, oh, it didn't do me any harm. But actually, someone pointed out to me years ago, the fact that you can remember that time that dad got a wooden spoon or mum got this, and it just shows it actually stayed with you in a subtle way. And you love your parents and you know they love you, but we can do this differently and we can do it better.
Thank you, Rachel. Thank you.
You're welcome. That's all I have.
Thank you. I think there was an issue back in Wales in relation to did the prosecution, the public prosecution, the PPS, not say that it would lead to prosecutions for parents who smack their children?
Not that I'm aware of, but I can absolutely check that out and get back to you.
It is, no doubt, it is a controversial issue. Sorry, it is an issue. There are differing views on it. I think maybe that's a better way of putting it. I would have a particular view as a parent, and I would not want to lose the right to be able to chastise my children, and I have done as a parent, but I did it in love. I had a minister who always used to say to me, and I think it was a very true saying, if you can never use that hand in love, never use it to smack a child. I think that is sometimes good advice. However, that's a personal view. I'm not speaking on behalf of this committee. Just want to check, is any other members? Robin?
Yes. I did.
Sorry,
yes. I didn't realise Rachel had finished her. You
think Rachel had more questions?
I have plenty more questions. I'm just married with time.
It's just a very simple one, and both parties have mentioned it, and that is around clause 3 and the payment issue. And I think I get what you're saying in your evidence, but maybe you could expand on that.
Yeah. I suppose we know that Clause 3 is intended to remove legislative references to prostitution and pornography, and we're totally supportive of that. It absolutely misrepresents the harm to children within these contexts, and it masks the abuse that happens. But I suppose while it's not intended to look further at these provisions within this bill, we did take the opportunity to raise the definition of payment in the context of these offences, because it is problematic for us. I'll refer to the legislation. Article 41.5 of the Sexual Offences Northern Ireland Order 2008 defines payment as any financial advantage, including the discharge of an obligation to pay or the provision of goods or services, including sexual services, gratuitously or at a discount. I suppose the issue there is that that's very focused on tangible rewards. It's the financial. And many CSE cases may involve a tangible element or a financial element, such as accommodation or money or drugs or alcohol, etc. But some may not. And many CSE cases involve complex dynamics between the victim and the perpetrator. And they may involve intangible exchange or rewards, such as protection or affection for the victim. Also, the current payment definition doesn't reflect the policy definition in the Regional Cooperating to Safeguard Children guidance, which in its definition is that CSE occurs where an individual or group takes advantage of an imbalance of power to coerce or manipulate a child or a young person under the age of 18 into sexual activity in exchange for something the victim needs or wants, and or the financial advantage or increased status of the perpetrator or facilitator. The victim may have been sexually exploited even if the sexual activity appears consensual. So I suppose for us, we would want the committee to consider the definition payment, especially with regard to the potential of inclusion of other inducements, for example, to ensure that it is in line with the regional guidance, but also that it's broad enough to capture the full range of CSE cases, some of which may not involve that tangible financial reward, and it may be an intangible reward such as affection or protection because of the nature of CSE. We think that it's necessary just to cover the inducement for sexual services which could be non-financial.
Could I add to that? I caught up with our service manager for our service scene that I'd mentioned at the start, and I said, look, you know, we have this question of the definition of payment, and is that what you see with the young people that you support who've been exploited? And she said, in the vast majority of cases, it's not tangible. It's this sense of belonging, it's affection, it's attention. It's those different things that you can't put your finger on. So if we narrow this definition again, we're actually going to leave out the vast majority of cases. That's the reality here in Northern Ireland. And I think that we need to make sure that our law actually reflects what's happening here, rather than kind of keeping it tight to something that's imagined elsewhere.
And in terms of the Bernardo's report, not a world away.
Yes.
I presume we have a copy of that, Chair.
We can get that, yeah.
Absolutely. I mean, I would recommend reading that report, but it is a really hard read, I have to say. And I read it again recently in preparation for this, and it's not one that you can read easily and it will stay with you. But it's the reality of what's happening here in Northern Ireland, and it will horrify you. But actually, I'm really glad you brought it up, because there's a quote that I've included in our evidence that I think really captures it. And after kind of looking at all the different cases that they were seeing and the case studies that they had, there was this comment in the report which said that although tangible goods were part of the currency of exchange in some of these situations, in most others, the returns for the young person were more intangible, relating to attention, affection, and or a sense of belonging. And we need to make sure that our legislation reflects that. That was 10 years ago. We're in 2021 now.
Yeah. And presume you've raised this with the department?
Well, I mean, it is part
Both parties are on the same page on this.
Absolutely.
Yeah. Absolutely.
And it's something that we have been saying for a long time. I mean, probably prior to 2011, before I was in Bernardo's, but, you know, it's something that we've been feeding back to the department for years. They did their CSE law review back in 2019, and it was something that we raised then. So I think we now need to get up to speed. We have this opportunity with the law to make sure we get it right.
And when you raised it with the department, what was their reaction to the intangible?
Well, I mean, I didn't have actually a discussion with them directly, and I would actually really welcome a discussion with them on this. I think the fact that we had been raising it in our submissions to them and have been raising it publicly for a long time, and then it wasn't reflected in the bill, I think is disappointing. They've had the evidence and they've had the opportunity, and maybe it's been an oversight, but I would welcome steps to amend that. Thank you so much for that, Robin.
Okay.
We can ask the question to the department in relation to it.
Certainly, I would welcome that, Chair.
Yeah.
Absolutely, thank you.
Yeah. Thank you, Chair.
Chair.
Yes, Peter.
Yeah, no, thank you, Chair. Yeah, no, just on a couple of points, and probably more by way of comment in terms of I mean, obviously, as with the Chair, I think there would be a bit of a difference of opinion, I think, for some of us on the broad issue of reasonable chastisement. But leaving that aside for the moment, I think you make, very valid points around ensuring that what definition we have of payment is one that is inclusive enough that doesn't enable particular crimes then to go unpunished because they don't fit into a very narrow definition of payment. Secondly, I think on the issue of I think there's a very strong case if we're looking at the motivational side of things then to then ensure that that is widely enough drawn that it can take in that again there isn't a loophole. I suppose just 2 points occur to me on the issue of intention. I think there will be a need for a very interesting conversation to be held with police and PSNI, on the basis that I think we want to make sure that whatever is drawn in terms of intention, it doesn't become simply a device by which it seemed to be too high a hurdle for prosecutions to take place successfully. I mean, I suppose where there's a balance to be struck, it is normal within most criminal offences for intent or the sort of the mens rea, would be in legal terms, to be there. So I suppose it's about trying to strike some level of balance where there is some level of intent, but it doesn't become that. But the point I just wanted to then finally just to pursue with regard, I think you make a very valid point in terms of the abuse of trust issue, that it shouldn't be too narrowly defined, that if it falls outside the narrow remit of religious organisations or sporting organisations, and to some extent I know we'll be looking to see what the department comes forward with. The only little bit of nervousness I have with that is I think we need to find a definition which is inclusive enough, and it's maybe the wording of whatever way that is framed, because I'm conscious of, I know that you'd use the if we look at terminologies around hobbies or extracurricular activities, that we don't almost create a category which then exclude other things, and that we have something that will be widely enough drawn. So it may well be just whatever way that's expressed. And then I think rather than particularly relying on guidance which would then be amended from time to time, I think if we have something which is, and I'm not quite sure what the exact wording would be, but is drawing widely enough then to cover all those potential situations where there's abuse of trust, and particularly where there's adults with children, I think it's probably more around the definition of that, rather than particular groups of categories, because I think if we come to groups of categories, there is a slight degree of danger that somebody then makes an argument in court that they don't fall precisely within that category and use that as a loophole to get out. So it's maybe just to respond just to those comments.
If I could just come in on the position of trust definition, thank you. I think that's a good point. That is something that we have that did come up in discussions in the workshop that we had with the department, and it is about how you make this as inclusive as possible. And there are other ways of doing it. I mean, Jersey would be more inclusive, the approach that they have taken, because they don't specify settings. And interestingly, the Sarah Champion amendment that I had mentioned earlier that has been put forward in England in relation to the Police Crime and Sentencing and Courts Bill would be more inclusive in that it removes reference for the discrete statutory settings and extends the criminal sanction to all adults in a position of trust who are involved in caring for, training, supervising or being in sole charge of a child. So there are ways that this has been done, and there are lots of different options that could be considered in terms of the inclusivity of this. If there was a concern, I suppose, from the committee that there would be things left off a list if we were to include hobby or extracurricular activity. But I do think that's just about choosing the right model. But I think we're all agreed that it needs to include all adults who are operating in a position of trust to all 16 and 17-year-olds. And I mean, NSPCC would absolutely relish being part of that debate and having further discussions with the committee, and would love to offer, once we see the text of the amendment, to brief the committee and have further conversations about that and try to arrive at what is something that we all can live with and feel is appropriately inclusive.
Yeah.
Thank you. Okay, Peter, thank you.
Yeah, thank you.
Any more questions? No? Okay. Thank you. I think that's just to check there's nobody else that has any other question. Can I thank you, Orla, Natalie and Trasa, for your attendance here today. I think Orla got off very easy.
I did, that was enjoyable actually.
She did all the work though.
You did all the work. You did all the work before you came, Orla. No, thank you.
The brains behind the organisation.
And also, and this is not to pick out one organisation over another, because I wouldn't do that, but also to thank Bernardo's for the joy they give us with Farah.
Oh yeah,
in
she's
the advert.
fantastic, isn't she?
She brings joy into our home. When I am at home for supper, because I think she just brings a smile to all our faces. So
yep, we love her
she
too.
is
So glad.
She is a star.
She really
she really is. So you pass that on to her.
I absolutely will. Thank you so much.
And thank you to NSPCA as well for all the work that you do.
Thank you very much.
And thank you for your time today.
Thank you.
Members, we don't have to pause now because our next presentation from the Children's Commissioner is in Starleaf, so we're not going to have to take any time out, so thank you for your help in that. And can I welcome the Children's Commissioner for Young People to the committee again. Assume it's good to see you, and trust that you're keeping okay. And I think we also have Jacqueline with us as well, who is the Policy and Research Officer in the Commissioner's Office. So just to just go straight to your comments, and then if there's questions, members will be able to put those. But you're welcome again to the committee. Thank you.
Thank you very much, Chair, and it's great to be with you. And this may well be very repetitive because I think Bernardo's and NSPCC have covered quite a lot of the issues. So hopefully this will be quite a quick session. But I have a few remarks by way of opening. And as you rightly say, Jacqueline is here to answer the detail. Like Orla, she has done all the work. And also, again, to send apologies on behalf of our Chief Executive, who hasn't been able to join us today. So, as I say, I want to thank the committee for the opportunity to give evidence today regarding the Justice, Sexual Offences and Trafficking Victims Bill, and warmly welcome any legislation which seeks to better protect victims of sexual offences and trafficking. I would also like to commend, and you've already heard evidence of this from NSPCC and Bernardo's, but commend departmental officials for their willingness to engage with my team on this bill, and they've been really, really helpful and cooperative. So you'll be aware that the legislation that established my office requires us to have regard to all relevant provisions of the United Nations Conventions on the Rights of the Child, and it is within this context that our written and oral evidence is, of course, based. Today's evidence is not intended to be comprehensive across all clauses of the bill, but instead to address some key aspects which mostly directly engage children and young people's rights and best interests, and which were highlighted in our written submission. And it's unlikely we'll be going into the same detail that you've already heard from Bernardo's and NSP. The UN Committee on the Rights of the Child is instructive in reminding governments that all children up to the age of 18 years are considered vulnerable, and this is regardless of the age of sexual consent. It highlights the requirement that while respecting children's developing autonomy, young people under 18 must be afforded robust safeguards. The Sexual Offences Order of 2008 did not provide adequate levels of protection for all children up to the age of 18 against all sexual offences, and we would hope that this bill that we're discussing today will rectify that situation. Examples of our concerns in this area can be seen in Clause 2, which, as you know, relates to grooming. While we broadly welcome the intention of the clause, which includes adults masquerading as a child, and you already talked at length about that, and communicating with a child or children with the intent to groom, the protection of the offence should apply fully to all children under 18 and not just 16. And that the reasonable belief or rebuttal defence whereby a defendant is afforded access to a defence that they did not believe a child was under a certain age, if it's 13 years or under 16 years, and that should be amended, at least reverse the burden of proof. In another example, while we welcome the intention of the provisions in Clause 3 regarding miscellaneous amendments to sexual offences, which apply up to the age of 18, we again highlight concerns regarding the defence of reasonable belief and the need to address this in order to ensure that legal protections apply equally and evenly to all children up to 18. In other comments of the proposals, and again I'm repeating what you've already heard, but it's worth repeating, within this clause, we welcome the move to amend references to child prostitution and child pornography to better reflect the abuse and exploitation that is represented in these offences. And again, we support the call, the definition of payment extends beyond tangible forms to non-tangible forms, and you've heard some excellent examples of that already. I'm disappointed that the bill does not address wider concerns regarding the need to ensure that all children up to 18 years of age are afforded safeguards under abduction and recovery arrangements, and regardless of age, care or other status in Clause 18 relating to SOPOs. As with other areas of the bill, concerns have been repeatedly raised on this point, including by the 2014 independent inquiry into CSC, and more recently in 2020 by CJI and the Leonard report into the effectiveness of safeguarding boards, member agencies in responding to CSC. In a separate point on how the provisions of the bill engage with children under 18, Nikki notes the committee will wish to consider how children who display sexually harmful behaviour will be within the scope of clauses such as Clause 1, which relates to voyeurism. As with all such provisions which may apply to children, it is of central importance that arrangements effectively address harmful or abusive behaviour, whilst also seeking to divert children from the criminal justice system and ensure that they have access to the proper supports, including therapeutic support, to ensure that such behaviour is not repeated. Turning to the scope of the bill. As stated in our written submission, while I welcome moves to enhance legislative safeguarding protections through the bill, I also want to note my deep disappointment that the intended scope of the planned miscellaneous justice bill has not been brought forward, particularly in relation to children involved in the criminal justice system, and regret the lost opportunities to address these important issues within the current mandate. In relation to sexual offences and the protections in law, Nikki also notes disappointment that all areas, including the Department's 2019 consultation on CSE and law reform, are not being brought forward, including proposals regarding the defence of reasonable belief as highlighted already. So moving on to the amendments that are anticipated and the lengthy discussions you've just had on both the areas I want to address. We welcome the commitment of the Minister to bring forward provision to extend current abuse of trust protections, and our 2019 advice to the Department expressed serious concern that abuse of trust offences required amendment in order to offer effective protection to children and young people. Legislation must both reflect contemporary configurations of how services to children are delivered by and on behalf of statutory and government agencies, as well as voluntary community, sporting, arts and faith-based organisations, and must demonstrate a clear understanding of the power dynamics of sexual abuse when this is perpetrated by a person in a position of trust, regardless of setting. And as highlighted in our written submission to the committee and the advice to the Department, there is clear evidence of the vulnerability to exploitation and abuse of older children in such settings. And again, you've had a lengthy discussion about that with NSPCC and Bernardo's. I'd also like to ask the committee to note that next week on the 18th of November is the European Day of the Protection of Children from Sexual Exploitation and Sexual Abuse. And the theme this year is making the circle of trust truly safe for children, which is really relevant when we talk about abuse of trust. Moving on, my final comments on the scope of the bill are that I strongly recommend that as part of the legislation which seeks to improve public safety and better safeguard children and young people from harm, the committee give full consideration to ensuring that equal protection under the law for children from all forms of assault, including physical punishment, is addressed within the bill. We draw attention to the repeated recommendation of the UN Committee on the Rights of the Child and highlight the well-established evidence base which demonstrates that physical punishment is not effective in managing challenging behaviour by children, can result in poor outcomes for children, and can escalate into injurious abuse and maltreatment. There has been much progress in Northern Ireland in strengthening measures to protect children and others from many forms of harm, abuse and violence, and the bill represents an important opportunity to ensure the significant gap in legal protection for children is addressed. So that's my opening remarks, and I thank you for the opportunity to make them. And Jacqueline particularly will be very happy to respond to any comments or question that you may have. Thank you.
Was that a diversion that was just made there now? Was that? That sounds very like something I would do. No, Lucinda, thank you very much, and thank you for your presentation, also for the information you have you provided us. In terms of your statutory role, and obviously that is a very important piece of work of this legislature. That's how you come to consider this piece and other. It's within the remit of children. Apart from the issue which there's no consensus on, or generally no consensus on in Northern Ireland in relation to the reasonable defence, or the reasonable punishment defence. What other issue do you see is missing in this bill that could be deemed as an opportunity to protect children? Or is there anything else?
Yes, well, I suppose, right, okay, can I just go back about whether there's consensus in Northern Ireland or not with regards to the physical punishment of children? I think there is consensus. We did a significant piece of work in 2017 which showed that parents were generally very supportive of a change in the law and would have found that helpful. So I think, Chair, I would challenge the assumption that there's not consensus in Northern Ireland. I think the adults and certainly the young people I've spoken to in Northern Ireland are really up for the conversation and for the debate, and I look forward to that happening. I suppose so we've already talked about the abuse of trust and extending that, but also if we're talking specifically about sexual offences, the scope of the bill needs to look at how it protects 16 and 17-year-olds. What I referred to at the beginning was the need for us to have reform in areas of bail and remand for children and young people in the criminal justice system, reform of considerations around the minimum age of criminal responsibility need to be discussed and progressed, and there's a range of other youth justice reforms which I've already spoken to the committee about, which could have been addressed in the miscellaneous justice bill, but that opportunity has now been lost.
Okay. Thank you. Sinead Bradley.
Thank you, Chair, and thank you, Culla. It's good to see you, and Jacqueline, on your presentation. Culla, I suppose I would seek your advice in terms of, as a committee, we're looking to be quite robust in terms of getting a really worthy piece of legislation that's going to have the effect that it's setting out to have. And in terms of, for example, Clause 1 and Clause 2, where we're talking about burden of proof and, the intent behind the person, I'm really mindful, and it's always in the back of my mind, on every piece of legislation that we've worked on, to be fair, through this committee, that the age of criminality in Northern Ireland being where it is, and it almost feels, because I think there's also a right of a child not to be mature, not to have learned all of life's lessons. Sorry, I don't know if you can still hear me.
Yes,
I can. Yes,
sorry.
I can. Yeah, I can.
So, not to have learned all of life's lessons, and I almost feel that we could be setting up almost a legislative entrapment for a new world of, we know young people have access to phones now, that's becoming a very normal thing, and yet there's this legislation, and rightly so, and I support all the arguments for it, in terms of upskirting and downblousing, for example. And we're relying, and I will never tire of talking about the need for the RSE programme, because if we have these things on statute books, we owe it to those children to have them well educated on, what normal behaviour is and is not. And I just wonder if you would share those concerns, and if you feel there is any way other than the RSE programme, which is almost something that happens after the legislation's put in place, but is there another way of us safeguarding young people?
Okay, so I think you're absolutely right, and it's right to say a good RSE program that talks about consent and talks about impact actually is the best preventative tool we have available to us. So, but let's set that aside. And let's set aside the fact that we haven't got a reasonable age of criminal responsibility, which should be nearer to 16 than it is currently, which is at 10. Now, raising the age of criminal responsibility does not remove working or challenging a child's behaviour. It just removes the need for a criminal justice response. And they're two very, so it does support the child to understand what they've done wrong, to undertake any intervention supports, particularly therapeutic ones, to ensure they don't behave like that. And that is one of the things that we're really keen about. We cannot deny a child or anyone who has been victimised by a child the right to be recognised as a victim of a sexual crime. We cannot take that away from them. But what we must do, particularly when it's a child, because they're a child and because we see the possibilities, is work with them in a way that's most effective. And that is often by diverting them from the criminal justice system, as we do with a lot of children who have undertaken sexually harmful behaviours, because we have really good therapeutic interventions both within the statutory criminal justice system and outside of it. And that is the way we would go. We would go by diverting them where appropriate from the system, because as you're quite right, as we increase offences, we increase the likelihood, without good RSE, without good early intervention and prevention, we increase the likelihood of bringing children and young people into the criminal justice system, and by them having a criminal record that says they're a sex offender, and that will stay with them for the rest of their lives. And we need to prevent that where at all possible, unless they do continue to pose a significant risk to others. So I think we do need to embed programs and supports that ensure that children who perpetrate such acts don't do it anymore, and if where possible, avoid the criminal justice system. And I won't miss the opportunity, because we're Hansarded, to say that I still would like to see the age of criminal responsibility raised significantly from where it is now.
Thank you, Killa. Yeah, thank you. I appreciate that. And I want to also let you know, I hear you. I hear you when you say about what's not in this bill and the opportunity. I think a lot of us were hoping that the breadth would have been there to take in the likes of just that point and many others, because I think the safeguarding piece is, a missing link in a lot of legislation we're doing at the moment. So, and I appreciate, I do know from your written submission, both yourself and Jacqueline appear to be very much aligned with the earlier submission. So I won't rehearse that again, but I genuinely appreciate your submission. Thank you, Killa. Thank you.
Thank you, Sinead. Gemma.
Thank you, Chair, and thank you, Kula and Jacqueline, for presenting to us today, and also thank you for your written submission. Found it very useful, but I just want more information, or maybe a wee bit of clarity around the recommendation to expand Clause 2 to include enticing. What is this like? I'm sorry if this is a stupid question, but what does it actually mean, and what real life impact could this have?
So I'm going to hand over to Jacqueline, because we're getting technical here. So that's Jacqueline's job.
Can you hear me okay?
Yes. Yeah.
Thank you very much for your question. The issue of enticing was actually raised back in 2014 through the independent inquiry into CSE in Northern Ireland. That was one of the recommendations, and it's been an area that has been raised operationally by police in many ways, arguably, and in recent conversations with the department, we've talked through some of the detail of this. The previous amendments around grooming and the proposals within this bill seek to close that gap. So they seek to put in place legislative measures and tools that can be used at that very much early intervention point. What we would say around Clause 2, and I suppose it's really one of the core themes of Killa's presentation and our submission, is about asking the committee to look at how the provisions of the bill across all the clauses protect children and young people up to the age of 18, not the age of 16, not dependent on what their care status is, not getting confused with whether they fall into the category where a defence of reasonable belief could be engaged around prosecution, but as a fundamental principle in our safeguarding legislation, coming towards the end of 2020, moving into 2021, are we working on the basis that those legislative protections will be afforded evenly to all children up to 18? That is something that has been raised directly by the United Nations Committee on the Rights of the Child in 2014 and 2016 on the 2008 Sexual Offences Order. They've also directly raised concerns about that defence of reasonable belief. It's also been raised in the 2014 inquiry into CSE I mentioned. And again, thinking about, and I'm very mindful of the committee's earlier discussions with witnesses about how will things work in practice, what does this mean operationally, because that's what all of us are very much focused on. Will this improve safeguarding outcomes for children? Will it improve outcomes around pursuit and prosecution of those who seek to harm and exploit and abuse them? But operationally, it's been raised last year by both the Criminal Justice Inspectorate into their inspection in CSE and also the 2020 independent evaluation of member agencies of the Safeguarding Board and their response to CSE as well. I hope that's a helpful answer.
Yes, Jacqueline, that's really helpful. Thank you. And you've actually answered my second question in that answer, so you'll be glad to know you're free. And Chair, that's all my questions. Thank you.
Thanks, Gemma. Rachel?
Thank you. Definitely not free. I suppose just to start off with a comment rather than a question, Cuala and Jacqueline, thank you for your very detailed submission. And I know this is going to continue to come up as it has done previously, and I do see a wider debate on this in committee, if not the Chamber, on equal protection. I do think this is a very big missed opportunity here in this bill, and that also applies, same comments, to minimum age of criminal responsibility. It's just, one of those ones that we'll keep plugging away at. 3 questions. The first is technical and on clause 18, and issues have been raised regarding SOPOs and safeguards, and what more needs to be done in the bill or done on this to cover abduction and recovery arrangements. If you could go into a wee bit more detail on that, please. And would having this on the face of the bill be an option, or does this require, regulation change or change of practice or policy?
Again, I think what we've said about that is that certainly the those orders should be extended to 18-year-olds across the board, not just if they've been in care. So that should clearly be on the face of the bill. But I'm again going to hand to Jacqueline around the detail of the remainder of your question. Jacqueline.
Yep, very important question, and yes, this is where the connections of the bill to parent, if you like, legislation is really important. So it's about linking through to both the Children Order and Article 68 provisions, and also the Child Abduction Order 1985. And it is, as Cuala has just said, it's about ensuring there's a mechanism in place that it's clearly defined, and this piece of legislation is such an opportunity to make sure that all young people are protected. The department, from discussions, is not looking further at this point. So from our perspective, it would be very helpful if the committee was of a view that they would like to explore that further with the department. I should say we are aware that there are areas where officials are continuing to work, such as on the defence of reasonable belief. So there may be some of the questions or areas, issues that are raised in the discussion where we just want to acknowledge that, where we know the department is continuing working otherwise, and then the areas where we have concern that there's not that momentum.
Thank you, Jacqueline. And just on that, they're not, like, the department are not looking at this particular area. Have they given you any particular reason why?
It wasn't part of the intention of the piece to look at widening scope further.
Okay. Thank you. Two more, and these are in relation to what's not in the bill. And the bill is obviously a trimmed down version of what it should have been and what the committee were promised last year. But one of the things, and it has been briefly mentioned, was the legislation governing bail and remand for children, and to strengthen the automatic presumption of bail and to introduce specific conditions to be met before a child can be remanded in custody. And I know the Chair had raised this, but could you give us any more information about why this is so important, and why, what would be the effect of not having it in the bill going forward, and would you welcome this being added through amendment if possible?
Well, something like, although we don't have high numbers of children in custody, but something like 94% of the children who have been in custody in the last year were there either on bail or remand. Often, not always, but often for the lack of being able to perfect bail, to get an address or mainly accommodation. That can't be right. Locking a child up, and that's what we're doing, locking a child up has to be a cause of last resort, and only for where a child has committed such a serious offence that they are likely to get a lengthy custodial sentence at the end of it, or they pose a significant risk. And the two things are aligned. Yet we know we lock children up in our custodial facility for reasons other than their offending. And that is a breach of decency, let alone children's rights, but also of the law. And that's not because the Youth Justice Agency say, come on in, we'll look after them. It's because there is insufficient services in the community for those children and young people. But that is not the issue for the criminal justice system to resolve. So we need to close that loophole in the bail arrangements that say the Juvenile Justice Centre cannot be used as a place of safety, and that children should only ever be remanded into custody if their offences are so serious that they would get, as I said, a lengthy custodial sentence. And we need that as a matter of age. It has been for years and years and years. Our custodial facility has been ill-used and badly used to accommodate children who are vulnerable and don't have a suitable accommodation in the community, and that's not right. So that's really why we have needed law reform, and the Law Commission reported on this about 10 years ago. I think it was, the Law Commission reported on this, and we're still sitting here 10 years later, and 10 years after the Youth Justice Review reported on this to make these recommendations, and here we still sit without the legislation having been updated and without these loopholes closed.
Thank you, Kayla. I suppose it's very important then for committee and also the Health Committee to be considering this. Whenever the departments are moving forward with the changes to, with justice and the campus, this is all completely interlinked, so we can't really be doing one without the other.
Absolutely.
Finally, for me again, similar to the previous question about what's not in the bill, the provisions absent from the bill which would have addressed the 2019 Supreme Court judgment on disclosure of non-court disposals for under 18s. Could you tell us any more about this and whether you would encourage the committee to look at this for this bill?
I suppose I'm not going to tell you. Another recommendation of the Youth Justice Review was about wiping a child's slate clean, and the importance of a child going into adulthood without carrying the burden of their previous offences, being allowed to put their past behind them, because we know children generally grow out of offending. And often, they enter as a hook. But we know also the importance of employment in desistance from offending, and the wariness of employers to employ somebody with a criminal record. So there still remains an opportunity lost in helping children to wipe the slate clean. My understanding is Access and I are being a little bit more circumspect about not sharing non-court disposals, and they shouldn't. And we should only share criminal justice outcomes of children we should stop showing them as adults unless the behaviour continues into adulthood and they continue to present a risk. But we should allow children to wipe the slate clean and be able to move on in their lives. I'm not sure if that's what you're referring to, Rachel, because I can't pull the judgment down into my mind just yet. I'm showing my ignorance here.
No, you're grand. Thank you. That's all from me, Chair.
Okay, thank you, Rachel. Okay, just want to check. No other members? Any questions? Oh, Peter, yes.
Peter Ware is waving his hand. I'm not sure whether he's saying hello or he wants to ask a question, Chair.
No, I think he's going to ask a question, no. Thanks. Peter? You're muted, Peter.
Yes, no, I suppose you could say it's both in that regard, Chair. I suppose we do have the same degree of irony that I think at the moment that I think probably geographically, Coola and myself are actually closer to each other than either of us are.
And Jacqueline, the three of us could probably go out in the street and have a conversation right now.
I'm tempted to say, Coola, I've even brought my Man United mug with me just to make you feel fully.
Well, I'm sorry for your troubles, Peter.
Indeed. What I would say is, obviously, given there's a considerable overlap in terms of your detailed evidence with yourselves in terms of some of the issues and the NSPCC and Bernardo, so I'll just maybe confine myself to one particular issue rather than try to go over a range of things. You raise, I think, the very important issue at clauses 2 and 3 of the issue of burden of proof on reasonable belief. And if I'm interpreting what has been both in writing and in terms of oral, but something which I would concur with you in saying that your concern is to ensure that there is no reversal of that burden of proof, i.e. that if someone is going to rely on the issue of reasonable belief, that the onus is on the alleged perpetrator to prove that and discharge the burden of proof, rather than the prosecution indicating that or having to prove it themselves in that regard. I just wonder in relation to that, and I think from that point of view, this will be an issue. I know you effectively recommend to the committee that the committee seeks that clarification and reassurance that the department isn't seeking to reverse that burden of proof. And I think that's something I think that the committee will want to ask. But I'm just wondering, in relation to that, is that simply sort of, from your point of view, a little bit of a belt and braces type exercise to ensure that that isn't the case? Or do you have anything which would lead you to believe that the department is potentially reversing that burden of proof? And also, I think Jacqueline mentioned that there was ongoing discussions with the department. Has there been something that you've got any level of direct clarity from departmental officials, albeit that it would be something that, even if there was assurances given by officials, that it would be something we'd want to put very much that clarity on the record?
Jacqueline?
Yes, thank you very much for the question. This was an issue that the department looked at in quite a lot of detail in their 2019 consultation on law reform across a number of areas relating to CSE and sexual offences. And in the consultation, they were proposing not just reversing the burden of proof, which is also a UN Committee on the Rights of the Child direct recommendation, but also looking at the potential to limit the circumstances in which the defence could be accessed. We were supportive of both those aspects of the proposals. We appreciate there are some complexities, I think, have arisen in discussions they've had with other members of the criminal justice family, but we are aware that they're continuing to work on that. And our understanding is that they would hope that potentially there could be something introduced in the next mandate and the early stages of the next mandate. Of course, you'll be aware and appreciate our concerns that that's not within this mandate, that we do not know what may happen moving out of this mandate, and that we're disappointed that the opportunity hasn't been taken to secure this.
Yeah, Jacqueline, then just I suppose the kind of follow-up just in relation to that. So obviously there's the issue of where the burden of proof should lie. Yeah. If you could maybe just a little bit expand, because I don't think it's particularly detailed in the submission so far. You mentioned obviously at an earlier consideration of the limitations in which the defence could be used in a more limited set of circumstances. I'm just wondering if you could maybe expand on that a little bit in terms of where you would see the limitations placed on that as a defence, and again whether that's something that potentially could be there in the face of the bill.
Yes, and I'll seamlessly reach for my piece of paper. Yes, so that was really building on the department looking at arrangements that were being taken forward in Scotland, and we were supportive of them seeking to look further at that. Now, if I'm not able to find this quickly in my notes, so examples would be limiting access to the defence if an individual had a previous conviction of sexual offence against a child, if they'd been made subject to a risk of harm, a risk of sexual harm order, and where defendants may have been charged with the relevant sexual offence. So
I think that'd be useful. I would maybe suggest maybe as a follow-up.
Yeah, we'll
Nikki could provide that in writing to us. I think that would be helpful as well.
Absolutely.
Okay, thank you.
Okay. Ulla and Jacqueline, thank you very much for your time and for your submission to us and for your continued work with us as a committee. And we wish you well. No doubt we will be returning to many of these issues over the weeks and months. That if there is months, I don't know, but we'll see what where this the next few weeks leads us. But hopefully we'll be in a position for the bill to be presented to the Assembly. So thank you for your time, and I wish you well the rest of the evening. Thank you.
Thank you very much, Chair, and we look forward to engaging with you over the next few months into next year. Thank you very much.
All right, bye. Okay, members, thank you. And just to really wrap all of those up, and thank you for your engagement and your time in relation to those presentations. I think there's a wealth of work and issues in there which will no doubt keep us busy over the next few weeks. Just to get agreement from yourselves that we refer the specific issues raised by CARE, Grace and Justice Project, and the proposed amendments in relation to the trafficking and exploitation sections of the bill to the department and to other departments if necessary for response. And also there was a number of other issues that were raised that the clerk along with the staff will go through, and we will then bring those to inform you next week as to what all of that actually means. Okay, agreed? Thank you. Okay, members, that brings us to item 8, which is the protection from stalking bill, and it's the informal deliberations. And can I refer you to pages 161 through to 257 of today's pack. And at last week's meeting, the committee discussed the clauses of the stalking bill and a number of other issues raised and evidence received that are not currently covered in the bill, and agreed to request further information from the department and the position of the Minister in relation to a number of the potential amendments. The clerk's memo setting out the committee position and the department response providing the further information requested are at pages 8 to 12 in the table pack, and we were also emailed to members yesterday. We'll now work through the clauses of the bill of which the committee has not yet reached a position on the additional issues, and seek views in light of the further information and the clarification provided by the department. We can discuss the issues raised, indicate whether we are content with the clauses and any proposed amendments that we wish to amend particular clauses, or are minded to reject particular clauses. Members need more time to consider a particular clause or clauses. The committee can complete its deliberation next week as to allow the maximum time to consider the text of the proposed amendments. Formal clause by clause consideration will take place at our meeting on the 25th of November. In accepting a clause or amendment, members can express a view, make comments, and the committee can also make recommendations, for example, with regards to the implementation or outworking of the clause, and these will be reflected in the committee's report on the bill. Also to advise members that we have members from the Justice Department joining us, and we thank Brian, Andrew and Barbara for being in attendance again today. So should there be any questions and if we require any further information or clarification. We'll go straight then to clause 2, which is the offence of threatening or abusive behaviour. Department officials agreed to provide the views of the legislative draft person regarding why the reference to a reasonable person in 2B is wording differently to that used in clause 1. Confirmation that nothing's been created by the use of different wording, and whether there is any advantage in changing the wording. It is the response in the response received yesterday. The department has indicated that the draftsman has confirmed that under clause 2, the prosecution has to prove what the accused person did, how a reasonable person will be affected by what was done, and the accused person's state of mind. It may also have to rebut the defence by proving that what was done was not reasonable. The department's legal advisers have also outlined that clause 2(1)b should not be read as implying a reasonable victim as such, but rather as a mechanism for specifying the scope of the behaviour to be captured, and is a different and very specific use of the reasonable person test, and injects an objective element that must apply to clause 2 offence. The department is satisfied that no lacuna is created by the use of different wording, and believes that there is no benefit in attempting to change the existing wording. And so it's to seek the views of members on clause 2 of the bill, and whether, in light of the additional information provided, they are content with the clause, wish to discuss the amending of it, or require any further information. As I said, the officials are available, or wish to discuss rejecting it, or wish to highlight any views, comments for inclusion in the committee report. Any comments? Okay, thank you. Clause 17, guidance. Committee agreed to request clarification from the department regarding whether the guidance to be provided under clause 17 will only cover the exercise of the Chief Constable's functions relating to stalking protection orders and interim stalking protection orders, and if so, what consideration, if any, the department has given to expanding the scope of the guidance so that it is more closely resembles that provided for in the Domestic Abuse and Civil Proceedings Act, under which the department must issue guidance in relation to the domestic abuse offence or any other matters as to the criminal law and procedure relating to domestic abuse. The department has indicated that the intention is that the guidance will also include a specific section on the stalking offence, and will be published and available to all criminal justice agencies and non-government and voluntary organisations for assistance and guidance. And just to remind members that the department provided the text of the proposed amendment to clause 17 to implement the proposal by the Assembly Examiner of Statutory Rules, that the guidance in respect of the Chief Constable's functions in relation to the stalking protection orders should be laid in the Assembly, and that can be found at page 163 of today's meeting pack. And it's to really seek the views of the members of clause 17 of the bill, and whether, in the light of the additional information provided, we are content with the clause. Rachel.
Thank you, Chair. You'll be unsurprised to know that I would not be content with the department's response. I think that despite the intention being there written down in this response to us, that's not what it reads on the face of the bill. I think the bill as it's drafted is quite clear that this guidance is only for the Chief Constable, and it doesn't make any reference to wider exercise of public functions and those that are going to be dealing with this new law. So you're talking criminal justice agencies, you're talking the effects of this bill. So I would not be content with the departmental amendment as it stands, and Stephanie's probably going to start shaking, talking maybe about an amendment to an amendment, or maybe a suggestion of another amendment. I'm aware that the department are bringing forward an amendment on this already, so I certainly would be supportive of the committee looking at putting in something quite similar to the guidance section. I believe it's section 30 or clause 30 in the Domestic Abuse and Civil Proceedings Act, that would sort of encompass all of those matters, as well as having the Chief Constable's guidance, which obviously is needed, and obviously with the department then laying the guidance in the Assembly.
Okay, thank you. And just so the members are here and also join us on Starleaf, Stephanie Mallon is present with us from the bill clerk and will be available to take instructions on any proposed amendments, but that cannot be done until we get to closed session. So just for clarity, in case anybody wants the reason why they may say that Stephanie's here, but we will go into closed session to deal with that, okay? So if we want to just park that issue and move on. Okay, thank you. Stalking register. The committee agreed to ask the department what further consideration that had given to the introduction of a stalking register. The department has confirmed that it has no plans to introduce a register for stalkers in Northern Ireland, and is content that where possible victims raise concerns about stalking behaviour of the PSNI, its access to the criminal records view will ensure that links to any stalking convictions will be immediately picked up. Discussions are ongoing with colleagues in the Public Protection Branch regarding the stalking offence and stalking protection orders coming within public protection arrangements, which will enable agencies to better manage the risk from stalking offenders. SOPs will place a notification requirement on the perpetrator, and this information provides a form of register not dissimilar to what is commonly referred to as the Sexual Offenders Register, although no such register actually exists. And it's to check or to seek members' view as to whether they are content to note the response in relation to the issue, or whether we require any further information or clarification. Okay, thank you. Just make sure that there's no one on Starleaf. No, thank you. That's okay. The potential amendments on the data collection, mandatory training, and to place a requirement on the department to report on the operations of the offence. The committee agreed that it is minded to bring forward amendments to provide for data collection, mandatory training, and to place a requirement on the department to report on the operation of the offence, similar to the amendments brought forward in relation to the Domestic Abuse and Civil Proceedings Act, and agreed to ascertain whether the Minister is willing to bring forward these amendments. The department has stated that it does not consider that the addition of provisions relating to data collection, mandatory training, and the requirement to report on the operation of the offence is necessary or an appropriate inclusion in the bill, and has reiterated the actions that officials had previously outlined would be undertaken in these areas. The Minister, however, appreciates the Committee's desire to include these provisions in the bill, and has exceptionally agreed that they should be brought forward as departmental amendments. Due to the lead-in time required to prepare legally proofed instructions and pressures within the Office of the Legislative Council, the Department has indicated that it may not be in a position to share the final text of the amendments before the committee stage of the bill ends on the 10th of December, but officials will be happy to discuss the amendments at committee meeting prior to consideration stage. So, to ensure that amendments achieve the purpose the committee wants, the committee should consider the text of the draft amendments before concluding its consideration of the Protection from Stalking Bill. But given there is some doubt as to whether the text of the amendments will be available from the department in time, it would be prudent for the committee to ask the bill clerk to prepare draft amendments covering these areas as a contingency. So, as we've said earlier, this is an issue then that we can deal with when we go in to closed session, if there is no other comment by members. Okay, thank you. And that is in accordance with normal protocol. The issues in relation to talking to the bill clerk will take place in closed session at the end of this meeting. So we go into closed session now, or do we complete our business?
What I would suggest, Chair, is we have a number of other agenda items that shouldn't take too long. So if the committee would like to complete those first,
yes,
and then
okay.
we'll go into closed session
okay.
just at the end of those.
Okay, thank you. And can I just thank the officials who were in attendance. Brian, to you and your staff, thank you for your time with us this afternoon. Thank you. Okay, members, we will go then to item 9, which is the October monitoring round, pages 260 to 351. The departmental officials attended the committee at our meeting on the 30th of September to provide the oral evidence on the 2020-2021 October monitoring round and on the information gathering process of the 2022-2025 budget. Following the session, the committee requested further information on a number of issues, and the responses from the department is at pages 270 to 277 of the meeting pack. The department also provided a copy of the monitoring round forms submitted to the Department of Finance on the 11th of October and advised of a subsequent capital pressure agreed for Forensic Science Northern Ireland, which was just a capital easement surrendered to the Department of Finance. The committee agreed to ask for the details of this pressure, and the response is due tomorrow. The department has outlined the resource scale bids totalling almost 25 million were submitted in the October monitoring round, and 2 million was allocated for support services for victims of modern slavery and human trafficking, legal aid and legal costs in relation to police pension and litigation cases and compensation payments. Negotiations are ongoing with the Treasury in relation to the PSNI protocol costs and the compensation services costs relating to the change in the personal injury discount rate. The department will continue to review the unmet bids and the pressures of 1.275 million already being managed, and will submit bids in the January monitoring round as necessary. The department has also advised that a further capital easement of 10 million in relation to the PSNI Police College was returned to the Department of Finance, as there was no further business areas in the department in a position to avail of this level of funding at this stage. The relevant correspondence is at pages 280 to 283. The department has also provided details of the budget 2022-25 capital bids as requested by the committee, and this is at pages 260 to 269. The department has indicated that according to the current timetable, a draft budget will be published by the Finance Minister in mid-November, providing there is no slippage, and officials will provide an update on the draft budget and the oral evidence session in the January monitoring round, which is scheduled to take place on the 16th of December. The committee has requested information from 8 justice non-departmental public bodies regarding the budget, information gathering process and likely implications to assist consideration of the draft budget. And it's just, if members are content, to note the additional information provided by the department in regards to the October monitoring round and the 2022-25 budget capital bids, or whether there's any other clarification or information required. Thank you. There is a considerable amount of information there, members, and last night started to go through it, and I have to say I got to a stage where I was losing the will. So I'll have to revisit it again. Agenda item 10 is the forward work programme at pages 353 to 362. The committee previously agreed to give consideration to the capacity to schedule work items requested by the Department of Justice for November and December, once oral evidence sessions on the Justice Victims Bill has been agreed. At its meeting on the 14th of October and on the 21st of October, the committee agreed 11 oral evidence sessions to be scheduled on the bill during November, and a number of other work items requested by the department should be included in the work programme. The department has now provided a list of items of business it would like the committee to consider at the 3 meetings currently scheduled for December 2021. These include 3 oral evidence sessions and 14 written papers on a range of issues, including proposals for statutory rules. The committee's main priority is to progress the various justice bills. The committee stage of the Protection from Stalking Bill is due to finish on the 10th of December, and the informal deliberations and the formal clause-by-clause consideration and approval of the draft reports needed to be completed before that date. A number of informal meetings with victims of stalking also need to be completed by the end of next week, and members are asked to make themselves available for these if at all possible. Following the oral evidence sessions on the Justice Sexual Offences and Trafficking Bill in November, oral evidence sessions with departmental officials to discuss the issues raised in the evidence, and the informal deliberations on the bill will need to be progressed during December to enable the committee stage of the bill to be completed by the 28th of January. So it's to seek the agreement of the committee to schedule the work items requested by the Department in December, with the caveat that the oral briefing on the review of hate crime legislation currently proposed for the 16th of November may need to be deferred to January if the bill work necessitates this, and also to seek the agreement of members to move the oral evidence session on the responses to the consultation on non-fatal strangulation legislation and the proposed way forward with departmental officials, which is currently scheduled for a meeting on the 25th of November, to our meeting on the 2nd of December, as there are currently 4 oral evidence sessions on the Justice Bill due to take place on the 25th. And as discussed earlier in the meeting, officials intend to brief the committee on the department's draft budget when they attend the meeting on the 16th of December to discuss the January monitoring round, assuming there is no slippage in the current Department of Finance timetable. The timing of this briefing may, however, need to be revisited once the timescale for the Assembly committees to consider and respond on the budget becomes clear. And just one other item, and I'll bring, maybe Gemma, do you want to come in now? Have you a question?
Sure. Just on the stocktake on police and oversight and police ombudsman 5-year review, could we request that we get an updated note in advance of the 9th of December meeting? I don't think committee members should be bounced on an issue like that. So if we get it as soon as possible, the department has it.
We will get a briefing paper in advance, Gemma.
Oh, thank you.
Okay, thank you. There is a request from Women's Aid to give oral evidence to the Committee on the Justice Bill separately rather than with other organisations. And you remember that earlier the Women's Aid was part of the group that came to present to us, and obviously the Women's Aid have given us a very detailed response as well, but it's just the difficulty we have is trying to find a time to facilitate all of these, and it's not being disrespectful, I trust, to Women's Aid, nor is it in any way trying to limit any person's or organisation's contribution to the discussions around the Justice Bill, but it's going to not be very possible to get it all fitted in unless we take a separate day of the committee to do that. But are you happy that we just keep it as it is? Okay, thank you.
Chair,
yes.
Could I just add to that? I agree with you, but if Women's Aid were perhaps only partially presenting today in the hope that they were going to have a fuller window, maybe we could ask them, that we as members would be open to receiving any further written submissions for, to wider our consideration of their submission.
Yeah, okay. Yep.
Yes, just to clarify for members, they have been invited to attend as part of the group with the Women's Policy Group next week, so they have the opportunity to send a representative as part of that group who are going to be attending next week, and we will advise them that we'd also take any further written comments or information that they want as well.
Okay, thank you. And then item...
Sorry, Chair. It was just to get some clarification maybe from Christine. The PPS bulletin on sexual offences statistics came out this morning. Do we as a committee ever get an update or a briefing from the PPS whenever those come out? I know they're coming out annually.
We don't generally get a briefing. They've started to send and make sure that we get them, and they flag it up for us. And I know the director had offered, and I think the committee had accepted his proposal that he would come twice a year. Now, one of them was round statistics. Don't think it was that one in per se, but it was more general on their work, etc., and then another time. So we don't generally just get a briefing on that, but we could ask them. We need to look to see when he's going to come.
Yeah.
I suspect he'll be due to come before we finish.
Yes.
So we could, if you wanted, include that.
No, thank you. I'd appreciate that. I know if we had loads of time, we'd be looking, can we maybe have a look at and like an inquiry into this in terms of the handling of sexual offences in the criminal justice system. But we are well aware of the workload and timing. But just the recent statistics that have been published this morning, and just in relation to the Justice Bill that we are also working on, there's some concerning statistics.
If you saw those figures that were in the submission, was it care? You know, like, was there no prosecution? You know,
I mean, if you want, PPS are due to attend on the Justice Bill on the 25th of November. So if you want, we could flag up that there may be some questions around that statistical bulletin.
Certainly welcome that. Yeah.
I do. Okay. Thank you. Okay, members, thank you. And then we just go to correspondence. And just there are 7 items of correspondence, pages 364 to 554 in today's pack, and also at pages 26 to 123 of the table pack. And I'll just draw your attention to one of the items in the meeting pack and one in the tabled pack, and that is item 11.5 at page 414 of today's meeting pack. It's a response from the Department of Justice to the Committee's request for its position on the findings of the Regulation and Quality Improvement Authority report of a review of the services for vulnerable persons detained in Northern Ireland prisons, commissioned jointly by the Ministers of Health and Justice, and a copy of any plan to implement the recommendations in the timescales. And the Department has indicated that it welcomes the report, has accepted the 2 recommendations that are specifically for delivery by the Northern Ireland Prison Service, and the Department has confirmed that they can be delivered within the timescales outlined in the report. The Department also advised that it will work in partnership with the Health and Social Care colleagues to facilitate delivery of the other 14 recommendations, and will keep the Committee updated on those developments. And also at our meeting on the 14th of October, the Committee agreed to give consideration as to whether an oral evidence session on this matter should be arranged, possibly in conjunction with the Committee for Health, once the response from the Department was received. And so it's really to seek the views of members of whether, in light of the response from the Department, an oral evidence session, either in conjunction with the Health Committee or, if the Committee workload does not enable this to take place, with RQIE and the Health and Care officials together with the Prison Service officials, should be scheduled on this report, or whether a written update on progress to the delivery of the recommendations could be provided for in March of 2022. And I would suggest, if we could, we go for the written update for the March 2022. I know we would like to, if at all possible, to get all those individuals into the room. If it could be scheduled, we could do it. What do we where do we see that we could fit it in?
I suspect if the Committee wants to do an oral evidence session, we would need to look at doing it later in January or early February. I can't see us being able to fit it in before Christmas, put it that way. We'd also need to check the position with the Committee for Health, because I do know they have a very heavy legislative programme.
Could we check with them first and then see, and then we'll look at this within the next couple of weeks? Okay. Thank you. Item 11.9 at page 26 to 124, the table pack, is the criminal justice inspection, and it's how the criminal justice system in Northern Ireland treats females in conflict with the law, which was published on the 9th of November. The report makes 3 strategic and 5 operational recommendations for improvement to help achieve the change required, and it's to ask that we would seek the agreement of members to ask the Department for the response to the findings of the report and a copy of the action plan to address the recommendations. Agreed? And then the final one is in relation to the table pack at page 123, item 11.10. which is an invite to the committee members to attend the 50th ACRO AGM, which will be held on the 18th of November at 2:30 p.m. via Zoom. It also indicates that the current Chief Executive, Owen Liner, intends to retire. Unfortunately, this is the same time as the committee is meeting next week, and so we should note the invitation for the AGM and also write to Owen to thank her for her work as with NAACRO, and obviously she's been there considerable time, and to wish her best regards in her retirement. Agreed? Okay.
Agreed.
Sinead?
Sorry, no, Chair, you've answered my question on it. Thank you.
Okay, thank you. And just if members are content to approve the action, the items, the correspondence set out in the cover sheet, and agree. Thank you. And item 12, there's no chair's business. Any other business members want to raise?
Chair, can I make a quick
Sinead?
point?
Yep.
I just want to make members aware, we'll all be aware of the speed that we're trying to get legislation through the committee, and I have made a very 11th hour submission to the Damages Return on Investment Bill, and there was just something not sitting comfortably with me in terms of the tunnel vision I suppose we were asked as a committee to take on this bill, and I certainly found merit and weight in listening to stakeholders in ensuring we were doing the right thing with this bill, but I also was conscious that the bill as presented carried on that tunnel vision. It was a very closed door to those participants and people who have a specialism, which we identified that the department don't have and fairly, won't have access to, and the need for leaning on government actuaries. So I just wanted to make the committee aware of that. It wasn't something that I was withholding, but I'm glad that I got it in a timely fashion so we can, at later stages, then work through it. Okay. Thank you.
Thank you. Okay, just the date and time of next meeting, Thursday 18th, 2 p.m. in this room. And we'll now advise members that we'll now go into closed session for the discussion with the bill clerk. So I bring this meeting to a conclusion. Thank you. Yes, if you just take your ease for a couple of minutes until we have the bill clerk who'll come to us, but we'll go in with closed session now.